The September 18th meeting of the California Law Revision Commission is hereby called to order. Would staff call the roll to establish a quorum?
Sure. Starting with Commissioner B.
Present.
Senator Blake Spear has indicated that she will be joining, but I don't see her at this time. Commissioner Carrillo,
Present.
Commissioner Carrion and Kubas are not present. Commissioner Hebner,
Present.
Commissioner Jenkins,
Here.
Assemblymember Pacheco has indicated that she is not able to attend. Commissioner King. Here. And Chair Simpson.
Here. Just as a preliminary, I need to share with everyone that Chair Xochitl Carrion has resigned from the commission. And in a short while, we'll need to have election to fill the vacancy and also to have an election for the upcoming term, which starts October 11th. Item 1, the minutes. Any questions or comments on the minutes?
Move to adopt.
Sorry?
Move to adopt.
There's a motion. Is there a second? Is there any public comment on the minutes? Hearing none, seeing none. Call the roll.
I will. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Here, aye. Whatever. All right, well, I'm just getting used to this. Okay, administrative matters. Sharon?
Sure, I will be brief because I know we have a lot on the agenda today. Just a few items to update on. SB 470, which is the bill that extends the teleconferencing option through 2029, has passed the legislature and it was sent to the governor. So that's a bit of good news for this commission because it's really been very helpful for folks to be able to attend remotely and also for the public to participate remotely. I think that we've noticed that we have more remote participation than in-person participation. So it's really a valuable tool. As far as the budget goes, we're still doing fine, no changes. We are still looking into getting some official office space that will have offices, and we are still very thankful to Kara and the Office of Legislative Counsel for hosting us for now. We're also continuing to work on the website contract. I think we're very close. Christy's been working really hard. And so hopefully we'll have more information at the next meeting. We still are working on filling a vacancy on the legal staff, and hopefully we'll have a update for you at the next commission meeting.
Okay,
And that's it,
all right, thank you.
unless there are any questions.
Any questions or comments from, no? Seeing none? Commissioner suggestions. Any suggestions from the commissioners regarding topics, process, whatever? Seeing none, hearing none? Move on. Election of officers. With the vacancy of our chair, under our current handbook, we're obligated to have an election to fill the chair and potentially vice chair. And then after that, we should hold an election to fill those same offices starting October 11th, which is under our handbook is when the terms begin. So two sets of elections. On the first, we'll do the chair and vice chair for the remainder from now until October 11th. So is there a motion for election of a chair?
I move Rick for chair and Victor for vice chair.
Okay, is there a second?
I'll second.
It's been moved and seconded. Um, would,
We want to call for public comment on this limited issue.
is there public comment on this issue? In person or by whatever? Hearing none, seeing none. Ms. Staff, call the roll.
Yes. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins.
Aye.
Commissioner King. And Commissioner Simpson.
Aye. Well, thank you all. And then for the election to begin, for the term to begin October 11th, is there a motion? David?
Same motion, Rick for chair, Victor for vice chair.
Okay, is there a second?
Second.
It's been moved and seconded. Any comment or question from the public? Hearing none? Seeing none?
I call the question.
What's that?
I call the question.
Call the question. Okay. Please call the roll.
Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King, Commissioner Simpson.
Aye. Well, thank you all again. I think. I mean, we'll see. The next item is Commission Handbook Updates and CLRC Style Guide and Procedures Manual. My suggestion, and I'd be open to your views of commission members and the public, is that we move this to the December meeting. We just got the memo on it either yesterday or the day before.
Yeah, just a few days
Just a
ago.
couple days ago. It's quite long. I haven't had a chance to go through the whole thing myself. And there are some issues I think that deserve some consideration, like how many votes does it take to take actions on some things like that? So is there objection to moving this to the December agenda?
No objection, but I had a question.
Okay, Dave?
What was it in fact the practice to give out little plaques to former chairs? Because I never got one. And if there's a stack of those laying around before we dust them off,
I think we're
Could I
probably
have
gonna
one,
take
please?
that. I think we're going to take that up when we get to a December meeting.
but I might be in
didn't have
Tokyo,
one
so I might miss the December meeting. That's the only reason I raise it now.
Oh,
So I just want to,
David, I'll send
Yeah.
I'll send you one of my 8.
that would be fabulous. Thank you.
fair enough.
Nothing further.
Okay. So we'll move that to December. Let's see, and that was that. Okay, legislative program.
Yes, the legislative program, we really don't have much new or anything new to report on this. This one, there was AB 1073, which related to judicial recusal. That bill was held early on in the process. And so
Was it held in
it's-
policy or fiscal?
it was held, I think it was in policy.
Policy? Okay.
Yeah. So the other things that we reference in this memorandum is, as you all know, the state and local agency access to consumer information from consumer service providers is at the final report. We're fine tuning it. And so that should be ready to seek an author for the upcoming legislative session. And the Equal Rights Amendment study is on the agenda today. The version before you today is the final report, and if all is acceptable to the commission, we would also be ready to start looking for authors for that one. I
Okay.
think also at that time, I don't know if Dan Robbins is here. He was going to give an update on SB 25, the ULC's legislative proposal relating to pre-merger notification. And there he is. Thank you,
There it
Dan.
is, Dan, welcome.
Not this guy again. Oh. How about now?
There you go.
Good. Great. Thank you. Sorry, I was hiding over here because I needed a plug. So Dan Robbins, Uniform Law Commission, California Commission on Uniform State Laws. We are the sponsor of SB 25, the Pre-Merger Notification Act. I just wanted to give you a brief update. We, we had been making great progress, and just as a reminder, the state and the federal government can enforce the Clayton Act, our main merger law. However, under the Hart-Scott-Rodino Act, the federal government gets very large filings from the parties before a merger is approved. The state doesn't. So what often happens is the state AGs have to catch up, or there's subpoenas and litigation. It's not helpful. When I was a kid, I worked at the AG's office on the American Stores case, and we had 2 years of litigation because the FTC approved the deal. And then we came in and said, hey, wait a minute. We're talking about the #1 and #4 supermarkets in California. We should have a voice. So that's what this bill does. It requires parties to supply that information to California if the deal impacts California. It's very simple. We were making great progress, 36-1 in the Senate floor, thanks to Senator Blake Spear for her support. In Assembly Judice, 10-0, thanks to Assemblymember Pacheco, and 11-1 in Assembly Appropriations. So everything was going well. We did get some last-minute opposition from the CTIA. It represents companies like T-Mobile, AT&T, and other large folks in the wireless space. They were concerned about enhancing the confidentiality protections, making the timeframes for filing longer, and requiring return or destruction of materials, and also to require notice and opportunity to cure before the penalty provisions kick in. We also got some opposition from a couple of smaller chambers of commerce, African American Chamber, Hispanic Chamber, and Asian Chamber, suggesting that increases like this, changes like this to our merger law are unnecessary, and confidentiality provisions need to be enhanced, and they made some other arguments as well. So the net of this is the Senate Judiciary Chair, who's the author, asked me to meet with these people and the AG's office and try to see if there's a compromise, and then bring the bill back to the Assembly floor early in 2026 for a vote. So I'm engaged in that process. I'm going to work hard at it because I believe in the bill, and hopefully I'll give you good news sometime in January. I'm glad to take any questions.
Great. Any questions or comments from commissioners?
Very
Hearing
good.
none,
Great.
seeing none? Thank you.
And
Thank you, Dan.
congratulations, Mr. Chairman. In the Uniform Law Commission, if you serve as president and put in like 2,000 hours, you get a little pin. So I have that at the house, which I'll safeguard because unlike Commissioner Hebner, I only have one. So
All right, good to
Thank
know.
you all.
Yeah, that may help for the next debate about this stuff. Thank you, Dan. Let's see. We're still 5 minutes out from our 10:30 special order on the recodification of toxic substances. Shall we move quickly to the Equal Rights Amendment? Maybe do that one?
Yes, that works. Sarah will be back at the mic in just 2 minutes, maybe less.
All right. Sarah.
Good morning, Commissioners. I'm presenting Memorandum 2024-39 related to the Equal Rights Amendment study. As you'll recall, the Commission approved a revised tentative recommendation for public comment at the last June meeting, and the Commission did not receive any additional public comment. The staff did make minor clarifying and technical changes, including to the commission comment. The first change, adding "and actions," conforms to the parallel language in subdivision B3 that describes the scope of sex discrimination. And the second change replaces the term "rule," which, although used throughout the study, is not the standard description for a commission comment and is replaced with "section." I also included an update on a recent Supreme Court case, United States versus Skermeti. And although this case is about transgender individuals, issues very much present within the study, the court decided this case in such a way that the matter of sexual orientation was really not the focus, and thus it doesn't impact the commission's recommendation. The commission have any questions?
Yeah, any questions or comments from commissioners? Yeah, Maria.
Thank you, Sarah. It's a great report.
Yeah.
As usual. So the question I have is on that new case, and I don't think this affects our recommendation at all, but it's been puzzling me, is that in Skermeti, the statute explicitly referenced sex, and the intent of it was to ensure that minors are not getting care that does not conform with their biological sex. If I'm saying that right. So I really can't understand how they came up with the classifications of age and something else. which I'm-
Medical treatment, I believe.
and right. So the Supreme Court can do whatever it pleases, obviously. But my question is, our laws are strong, but do our laws prevent that type of analysis where you can get around the plain language of a regulation or some conduct by simply classifying it a certain way that doesn't use the word sex or gender identity?
And I'll look to Commissioner Carrillo for backup on this, but I believe this was so much in the interpretation of the law that I don't think there's anything preventing a similar interpretation in California, but I believe tenor of everything that we presented would hopefully guard against that.
May I?
Yeah. David.
I was going to make 2 points. One was before Commissioner B's comment, I agreed with the staff recommendation that there's no need to include this new case in the discussion. I mean, it exists, it's a thing. Leading into my second comment, I put it in the category of federal courts are going to do what federal courts are going to do, and we have no control over that. And so I both don't care about the result in this case, so there's no need to include it in the memo. And I also feel like this is going to happen again, and again, there will be nothing we can do about it. Because in this, as in many other equal protection cases, the classification is the determinative pivot point of the analysis. So if a federal court is going to, structure the classification in its analysis in a way that we might not do it, we don't have any control over that. We can't do anything to prevent it. So it's going to be what it's going to be. So I agree with Sarah. It is what it is, but there's kind of nothing we can do about it.
Okay.
Thanks.
Thank you.
Is there any public comment on this matter?
Not appear so.
Okay, neither in person or by.
And would the commission like to approve the attached draft final recommendation as a final recommendation in the study?
Okay, is there a motion to approve it as a final recommendation?
I'll move the recommendation.
Second.
And seconded, and thirded. Staff call the roll.
Sure. Thank you. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King, Commissioner Simpson.
Aye. Thank you. The hour of 10:30 having finally arrived, we can move back to item 4, the recodification of toxic substances statutes.
And-
And
Oh, I just
see.
wanted to recognize at this time that our ASL
yes,
translator is present, and thank you.
Steve.
Thank you. Good morning, everyone. We have two memoranda as usual on this study, the codification of toxic substances statutes. The first is again, presentation of the cumulative draft that we have been putting together. As a reminder, this is mostly a reference document. Each time when we approve new provisions or eventual inclusion in a tentative recommendation, we put it into the cumulative draft.
Right.
And the cumulative draft is so that the commissioners and the public can continue to see how we're progressing. It's actually been a big help because we've been working with Department of Toxic Substances Control, and they are able to look through the whole compilation and give us some advice about things work or maybe don't work as well. And then we can make some adjustments. Typically, this first memorandum, which is 2025-37, doesn't require any decisions by the commission. In this case, we noticed a couple technical changes that thought would be appropriate to make, and those are proposed in the memorandum. And so we would need a motion to approve those two technical changes. And then I can go on to the second memorandum.
Okay, is there and so the motion would be to approve the cumulative draft with those technical changes?
Well, we're actually just approving, I suppose
Oh, okay.
the motion would be to approve
Those
the
changes.
proposed changes.
Got it, okay.
Yes, and then they will,
Is there such a motion?
That's my motion.
David has moved. Is there a second?
Second.
Thank you. Staff call the roll?
Sure. So on the cumulative draft, Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King, and Commissioner Simpson.
Aye. Thank you. Okay, and the next one, Steve?
yes, thank you. This is memorandum 2025-38. It's the next portion memorandum that we present each meeting. This is the next chunk of provisions from the chapter of the Health and Safety Code that we're recodifying. And I'm happy to take any questions, but obviously we're not going to go through each provision. If the commission provisionally approves the proposed revisions to these provisions, then as indicated, they would then be approved for inclusion in the tentative recommendation, which will be coming, by the way, sometime hopefully next year, if in case anyone's wondering why this is taking as long as it is. And it would also go into the cumulative draft so that you would then see it at the subsequent meeting. I'm happy to answer any questions or take any notes if anybody has any comments.
Okay.
Actually, I don't know if we asked about any public comment on the cumulative draft memo, but we could probably include that now.
Okay, Kara.
Do you, for this, are you going back to the cumulative or this?
Oh,
No, I'm sorry. So
Oh, you want?
first I'll
public
ask for
comment
if
on-
there's any comment or question, if anybody has anything that they would want to
Oh,
point out to me for me
yeah,
to
okay.
note.
Okay, sorry.
is there any public? Wait a minute, are we asking for public comment? Public comment
I
on?
think we
the-
can ask for public comment on
both,
both the
yeah,
topics
on either.
at this
Right.
time.
On either.
Yeah.
Seeing none, hearing none? Okay, Kara.
Hi, Steve.
Hi.
I just wanted to make a comment on the section 85560. The new subdivision D, which is page 10.
Okay,
So there's a reference in D2 that references the person presenting the appliances. I just kind of had, the word presenting to me I understand why it's being used, but I think it might be more appropriate to use the actual text of the statute, that the person transporting, delivering, or selling the appliances, just so there's not any confusion about what presenting means. And I think that is.
So I appreciate this comment. I have to look at this is D2, the new
D2.
D2. Is that correct?
Yes, and it also appears in,
It's on line 21.
I see it in line 21 and continuing on to line 22.
and then also in line 38.
Okay, the thing that I'm wondering about, and I will take a look at this. I don't know that I can do this now. I mean, certainly the language is awkward or incorrect. We can certainly look at revising it. I'm thinking this may be the language which is in the code section right now. I don't know if that's your understanding or you're thinking that's our proposal.
I thought I compared it, but if you could just check that.
I'm happy to check it. Can I ask though, if that is the language in the existing code section, it still could be something that we would change. We're obviously
Right.
making a number of non-substantive changes when the language is awkward and it can be better understood in a different way. Would you want us to look at potentially revising it if it is existing language? You may be looking now. I don't know. I don't have the ability to do it right now, but either way, we can look at it. I just wanted to know whether your comment was, don't make that change, or whether your comment was, that's awkward language. Maybe you can think about revising it.
The actual language in the existing statute is on page 11, and I'm pretty sure I compared it to the language that's in the proposed draft. But if you could,
Okay,
so I'm pretty sure it's not there in the
okay,
existing statute.
okay. We can certainly put back I mean, that's the reason also for the staff note at the end. By the way,
Right.
in this draft, we typically have staff notes when we do have revision, and it's too difficult to do it by strikeout and underscore. All right, thank you.
Thank you. That was it for me.
Okay, any other comments? Let's see, we already asked for public comment, right? And so, we need a motion to approve.
We do both. We're doing one at a time or both?
Oh, for we didn't do the cumulative draft? Oh, we did. We did.
No, we did
Yeah.
that. We did that.
We
Yeah,
did
this
that.
would be to provisionally approve this proposed recodification of these sections with the understanding that we will again revise the section that Commissioner Jenkins just pointed out to restore
With that understanding, that's my
that
motion.
understanding, yes.
Yeah, okay. Good. Is there a second? Oh, that was a motion?
It was.
It was, okay. Was there a second?
Second.
Second. Okay. Staff, call the roll?
Yes. Okay, so this is the vote on the next portions for toxics. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye. Okay, now, Steve, you're still up. The terminology
up.
relating to persons with disabilities?
Yes, thank you. So this memorandum is a status report. We are continuing group that the legislature directed us to convene. 2 meetings. We have a 3rd meeting scheduled for next month. It will likely be our final meeting. Again, this study is to recommend non-substantive replacement of the terms dependent adult and dependent person as used throughout the codes. The terms appear in well over 100 code sections with new terms that are more respectful of the persons that are described by those terms, specifically, but not including persons with disabilities. I expect that at the next meeting, we will have a memorandum presenting the results or what the thoughts are of the working group. It will be an interesting memorandum. There have been lively discussions and many different ideas about what would be the most appropriate replacement terms and some, I wouldn't say hostility, but strong feelings against some of the choices as well. I doubt we're going to come up with a unanimous choice by the working group, but hopefully we'll have a majority and there will be pros and cons. And then the commission will eventually need to be discussing this, and I will try to present the issues as best as I can. And as was previewed previously, there's going to be a second issue, which is going to be more of a statutory issue in that the term is used often throughout the codes without a clearly applicable definition.
Okay.
And so that's going to be something of an issue because it won't be clear whether or not to replace the terms that are not necessarily defined. We're working with the terms that are defined. The other terms likely were intended to have the same definition, except there are 6 or 7 different definitions throughout the codes. So we'll have to work on that as well. But there will be
Good luck
some
with
work
that,
to do
yeah.
in this next meeting.
This is,
Any questions or comments?
any
about
questions or
this study?
comments from commission members? Is there any public comment? Seeing none, hearing none,
All right, there's no
Thank you.
decision needed on this memo, so thank you very much.
and
And
do we need to?
at this time, I think that we can thank the ASL translator
Right.
and we'll see you probably next time. Thank you.
Great, thank you so much.
Did we call for public comments on?
We did.
Okay, thank you.
So am I dismissed?
Yes.
Yes.
Thank you. Want to make sure. Thank you.
See
Have
you
a good day.
next, see you next time. Thank you so much.
Yeah, thank you.
Okay, antitrust law. This is going to be probably a long discussion, lots of issues. Staff will present each memo before public comment, and commissioners are encouraged to ask questions at any time. After the staff comment, after the public comment, staff will walk through the commissioners through the memo and the decision points. And then if the commission wants to adopt or remove options, staff will have a roll call at each decision point. Alternatively, if the commission directs staff to conduct additional analysis, then obviously no vote is needed. I'm going to suggest that we take up the issue of misuse of market power first rather than at the end, because it has a lot of potential interaction with single firm and mergers and acquisitions. And it'd be hard to sort of finish the discussion on either of those unless we deal with the misuse of market power thing first. So that's my suggestion for how we do it. And then I know Senator Blakespear isn't present yet, but is hoping to join us at some point for the antitrust thing. So when there's a vote taken on these, if Senator Blakespear isn't with us at the time, I'd like to put, as we do in the legislature, put the vote on call so that we could then, when and if Senator Blakespear joins us, we could lift the call and allow her to vote on it as well. So if there's no objection to that, why don't we go to public comment analysis and draft language options for misuse of market power.
Sure. Before I launch into it, I just wanted to let everybody know that we received 2 new public comments, one which I believe is relevant to this discussion from Google, and then there's another one from the UDW and ASME that relates to single firm conduct and mergers. And we should have a copy of these, a hard copy of these comments available for the public as well. So I will launch into misuse of market power. Sarah also worked a lot on this, so if I get anything wrong, Sarah, please interrupt me.
Jump up and raise your hands. Okay.
So the memorandum 2025-43 has public comment analysis and draft language for options for misuse of market power. You've seen previous draft language. Like other specific issues, we thought it would be beneficial to the commission to provide for additional time for public comment, which we did receive. As you can see in the memorandum, we have public comments from a coalition of business associations and Chamber of Commerce, California Life Sciences, and the California Chamber of Commerce. And then you will see, and there was a supplemental memorandum to this memorandum, which also includes additional public comment from the California Chamber of Commerce, the International Brotherhood of Teamsters, and several other unions, the Institute for Local Self-Reliance and others, and the Writers Guild of America. And as I just mentioned, I will try to capture the brief letter we received from Google just this morning. So going back to the main memo. So we did receive opposition to misuse of market power. Generally, the Coalition of Business Associations and Chamber of Commerce, California Life Sciences, and California Chamber of Commerce, and I believe the Chamber of Progress, and I believe now Google submitted comments specifically or raising concerns about establishing something in statute related to misuse of market power. Broadly, those entities agree that current law provides sufficient opportunities for the state to enforce existing federal antitrust laws, and that there's no need for reform at this time. They're also concerned that deviations from the current antitrust law would create uncertainty, deterring investment, and stunting job creation. And then moving on to the supplement, we did receive some at the time the first memorandum was posted. We did not have any comments in support of adopting a misuse of market power statutes, but subsequently we received comments from the Writers Guild of America, the International Brotherhood of Teamsters, and their partners, who believe that it would be beneficial to have something relating to mergers with respect to market power. So sorry, I'm toggling in between two memorandums because of the
Sure.
the additional public comments that we received after the original memo was posted. Like I said before, you've seen option one. I don't believe in, Sarah, can you help me out on this? I don't believe we received comments specifically in support of option one. Is that correct, Sarah? No,
There was-
there's, yeah, that is incorrect. I'm sorry.
Okay.
We did have comments from ISLR and partners that have encouraged the commission to adopt option one. The ISLR stands for the Institute for Local Self-Reliance. They had a number of other organizations joining them. You can see who they are on page 2 of the memorandum. Did I get that right, Sarah?
Yes.
Okay. So the question, and I know we're not gonna, we're gonna wait for public comment at the end of the memo, but the question before the commission is, would like the commission like the staff to make revisions or conduct further analysis on the option. On option one, in the main memo, it says, despite not having received comments expressly in support, that is no longer the case. We did receive comments in support, as I just summarized. Sarah, do you have anything to add to this portion?
I don't believe so. I just wanted to share that as of the first memorandum, we hadn't gotten any comments, and then they have been rolling in as evidenced by this morning. So we're glad to get all this robust public comment.
I'm wondering if it might make sense to now sort of hear about option two. So rather than sort of making, talking about changes to one of them, we can see the two and the difference between the two in the first place as to.
Sure, no,
So-
that makes sense. And before asking for changes, you would probably also benefit from the public comment, but we're happy to take questions and suggestions at this time as well.
Okay, are there,
From commission members.
okay, are there commissioner comments regarding option one? Seeing none, hearing none. Can we hear about option two and how it differs from option one?
Yeah, so option two, and I'm going to ask Sarah to correct me if I get anything wrong. It uses the same definition of substantial market power as stated in option one, but instead of declaring the listed conduct presumptively illegal, it uses a list of examples of the types of conduct that may be illegal if the purpose or effect of the conduct is likely to harm competition in more than a de minimis way. And you can see that list on page 6 in subdivision D. It's the CLS, California Life Sciences, did note that this was a slightly better option than option one. However, they believed it created new problems, stating the market definition and presumption issues remain, and the de minimis standard is vague and not recognized in antitrust law. So they are concerned about the uncertainty that would create. And I'm just going to flip over to the other memo to make sure I'm not missing.
And I'll
Sarah?
add, there is, the second option is a non-exclusive list. So there's the possibility that there may be other conduct that rises to that level as well.
I'm having a little trouble understanding. You could,
Sure. If you look I'm on memorandum 2025-43, and the option is on pages 5 and 6.
right.
So under subdivision C, it's a non-exclusive list. So there may be other behaviors that aren't listed that are harmful. And in option one, that was a finite list. So that's another distinction.
I'm
between
sorry,
the
I'm still having trouble understanding you. It's not too,
two. So
Sarah, can you lean into the microphone a little bit?
Sure.
I'm
Is that-
having trouble hearing you.
in option one, let's see, I'm scrolling up and down. We present a list that includes leveraging substantial market power, bundling and tying. We went through the case law and a lot of public comments on the sorts of behaviors that are traditionally particularly bad when engaged in by very large companies because of the influence they have over the entire market. So in option one, we said, okay, all of these things are presumptively illegal.
if you're a big company.
Yes. I mean, it is, you can rebut the presumption by showing by a preponderance of the evidence that the pro-competitive benefits outweigh the anti-competitive harm. In the second one, we have a similar list, but it's not absolute. We're suggesting that there are other actions that aren't included in those 8 that also may be bad. And should that be presented in that circumstance, the person with substantial market power can rebut this presumption by similarly a preponderance of the evidence that the pro-competitive benefits outweigh the anti-competitive harm. So, and the standard for the second one is that the conduct is likely to harm competition in more than a de minimis way. So there's really 2 differences between 1 and 2.
So the difference between the two is the list of potentially illegal conduct is the same in the two. The definition of who's big enough, what companies that are big enough to meet this threshold. But one, both of these shift the burden from the plaintiff to the defendant on this, or just,
It's yes, and it sets a different standard. So the plaintiff, and Cheryl, feel free to jump in. The plaintiff would be the government and says, hey, you're a person with substantial market power. So they prove the elements of, for example, in option 1, this would be subdivision B. So they can prove it by direct or indirect evidence. And then they can say, for option 1, you violated, you bundled. And we've decided that that is presumptively illegal. And the defendant could rebut that presumption by saying, here's evidence, and that there's a preponderance of the evidence that it's better than it is worse, basically. And then in the second one, after the plaintiff, let's say the government, proves the market power, and then not only identifies that act as having been bundling, but the purpose or effect of the conduct, not just that they did it, is likely to harm competition in more than a de minimis way. And then they can rebut that by saying, they rebut the presumption by saying that by a preponderance of the evidence that the pro-competitive benefits outweigh the anti-competitive harm, which again is centered that it's better than it is worse.
and those two, the way the defendant can rebut it is the same in both options, right?
It is.
Okay. And in the second option, the plaintiff, like the state, not only has to show that they did these actions, but that it's going to harm competition in more than a de minimis way. So,
Exactly.
okay.
And they're not bound to that list either. There could be a number 9, which for purposes of discussions could say getting coffee. And so they can say, well, you got coffee and that hurt competition too. So we'll add that.
Are there comments by members? David?
Yeah, I was going to suggest to my colleagues that we spike this and not pursue this idea further. And I have 2 reasons for doing that. One is that I think it's unnecessary, and 2, I think it's impossible. To me, there's 3 pieces here. One is defining substantial market power. There's the burden shifting piece, and then there's a list of things that to me read as anti-competitive behavior. And it's that third piece that I think makes this unnecessary, because all of the things that are listed in subdivision C would be Cartwright Act violations, I think, because they impair competition. So in that context, I'd be okay with taking subdivision C and either having that stand by itself or moving it into one of the other pieces we're currently contemplating, like single firm conduct, potentially. Having it stand by itself would probably be better, though, because a related point is the fact that this is unnecessary because we actually want all of these acts to apply to big firms and small firms.
Mm-hmm.
And so I feel like we're chasing our tails trying to come up with a workable definition, and I'll explain why that's impossible in a second, when we don't need to. And we actually, I think we don't want to limit these specific examples of anti-competitive behavior to only big players, because it would harm the marketplace if someone medium-sized or small-sized did these things. So the only part of this that I think that we can use is C, and we should use it someplace else. And then my second point on impossibility is, and I think we talked about this last time, I'm still troubled by the arbitrary nature of substantial market power as a concept, and the coat pegs that are currently in subdivision B that we're trying to hang our hats on. I'm still troubled by those because on the one hand, they're arbitrary and they're also subject to change over time. And they're also subject to things like creative corporate restructuring. Somebody is just going to reorganize their corporation to not fit this definition and then do whatever they want anyway. So I think it's impossible to do this in the first place, and it's ultimately a futile exercise. So I would suggest to my colleagues that we abandon this, and the only part of this we keep is potentially the criteria in subdivision C. That's my suggestion.
Okay.
And staff notes that the MMP provisions were meant to be in addition to any Clayton Act provisions. So I don't think it's entirely necessary if you're looking to reform antitrust merger or single firm conduct altogether. So-
So Sarah,
Yeah.
I didn't
Sure.
quite understand, or couldn't quite hear what you said, but I would just point out that in subdivision C, it still uses the term substantial market power. So even if this was moved over as a component of in single firm conduct and mergers, perhaps the commission would still need to grapple with whether to define that term and exactly what it would
Yeah.
mean. So it kind of imports
I would only
A
keep,
and
I would only
B.
keep the list.
Yeah, you keep the list, not the
Yeah,
heading.
not the preamble in C. I'd keep 1 through 8 and use that someplace else as non-exclusive examples of anti-competitive conduct.
Just keep, take
Okay,
that
okay.
list, take
Yeah.
the list.
Okay,
Because there is if I recall, there is a list in the Cartwright Act
Right,
of behavior, and I think some of the things are in there, these things are, but not all of them.
right. I mean, that would be useful. These are the kinds of things that, on the one hand could be alleged as anti-competitive conduct, and evidence of them is the kind of thing that a court could use as factors for establishing a finding of anti-competitive
Right.
conduct. So this is a useful list. We can make use of this, but the whole concept of trying to define substantial market power and then its misuse, that I think I'm just not sure we should go down that road.
I've had similar concerns myself that if a company achieves large market power by doing some of these things when it's small and medium size and then big, and it only becomes illegal when they're big, why weren't they illegal when they were small? On the other hand, if they become big because they're better at what they do than everybody else, better products, better advertising, more efficient, simply becoming big because you're good at what you do and better at what you do than your competitors, there's nothing inherently wrong with that, it seems to me. Other comments by commissioners? Yeah, Maria.
My question is whether we even need to move the list of conduct to single firm conduct,
Yeah.
or is the single firm conduct, the language that is proposed broad enough to address the issues that we're concerned about here, but it's kind of too hard and arbitrary to draft a separate section.
Right.
Yeah, in my view, it's kind of the difference between a standard and a set of bright line rules, so we could import this numbered list 1 through 8 into single firm conduct, for example, which has a fairly broad standard. And then, we could go belt and suspenders and include these as examples.
Including but not limited to. kind of
Exactly.
thing.
Yeah, yeah.
That's possible, yeah.
So
Other
Agreed. It's not necessary, but it could be included as a non-exhaustive list.
Other comments by commissioners? Seeing none, hearing none, should we?
sure. There are additional public comments in this supplement that we would like to go over with you. And I suspect that we have many folks on the line and some in the room who will want to clarify what they were suggesting to the commission in their comments.
Okay.
So the International Brotherhood of Teamsters and the folks that joined them suggested deeming exclusive dealing or tying by firms with substantial market power as per se illegal. Their suggested language appears on page 8 of the supplemental memo. The staff notes that this provision is drafted to preclude pro-competitive justification for the conduct of effectively making it a non-rebuttable presumption. The staff believes that this departs significantly from federal law, which reserves per se treatment for limited circumstances, and we do cite a United States Supreme Court, which cites other Supreme Court opinions for that proposition. So that's something to keep in mind when taking a look at that comment. The next comment from the International Brotherhood of Teamsters relates to creating a rebuttable presumption for certain restraints. That also appears on subdivision or on page 8 of the supplemental memo. As you can see in paragraphs 1 and 2, there is a bit of a focus on labor and how this is drafted, which makes sense since we're hearing from the International Brotherhood of Teamsters. And then in paragraph 3, they suggest an attorney general or rulemaking role for the California Attorney General. The commission considered a similar suggestion at a prior meeting and directed staff not to pursue at that time legislation or draft legislation that would create a rulemaking role for the Attorney General. Sarah, do you have anything you want to add to this one?
Thank you.
Okay.
Okay, so the question before the commission is, having seen these suggestions by the International Brotherhood of Teamster, does the commission have any feedback? And at a staff level, we would like to note that these groups were very kind in actually suggesting language. So we just wanted to acknowledge and appreciate that effort.
That's always helpful. Yeah.
So the final thing to discuss now is a draft proposal creating a rebuttable presumptions for single firm conduct. I think Commissioner Carrillo has touched on it a little bit in his suggestions. We, as reiterated by commission members today, the commission has concerns about new and untested rules, arbitrary thresholds to define the criteria for burden shifting, and that attempts to address such conduct in legislation at both the federal and state levels has been unsuccessful to date. You can see that in prior memorandum where we summarized the efforts at both the state and federal level, and we're not aware of anything that has actually been enacted. At this point, the staff actually worked very hard with our consultant, Cheryl Johnson, to try to come up with some language. But after reviewing the commission meeting, we thought it was prudent to come back to the commission and ask for some points of clarification. And if the commission is interested in seeing more on that, I think we have something that we could refine further and present to the commission at another meeting. So the concern was that broad language without specific thresholds to target specific companies and specific conduct, as the commission has already noted, could reach parties whose conduct may not be anti-competitive, and that could be the concerns with option 1 and option 2. But proposing a more narrowly drafted option requires establishing a series of arbitrary lines, as the commissioners have already noted, that will necessarily include some and exclude others. So the question before the commission is, would you like to see draft language reflecting the latter of what I just said, which is the something that would necessarily include but exclude others. And so what we're asking for is commission feedback on whether to draft a broad or very specific provisions for misuse of market power in the context of single firm conduct. And certainly you could give us that direction for mergers as well. And Sarah, do you have anything to add to this?
I do not. Thank you.
Okay. At this time, I think it's probably appropriate to take public comment.
Unless the commissioners have
Unless
any?
Commissioners have any further questions or comments? Okay, let's hear from the public.
So Sarah, can you ask the folks who are online to raise their hands if they want to make a public comment so we can
Get a sense of,
get
yeah.
a sense of how many people, and if for folks who are in the room with us, could you also raise your hand if you intend to comment on this? So we have, it looks like
at
two.
least two.
We have 2 online. We have 4 online and the audience, 2 in the audience.
Two on online. Oh, five online and 2 in the room. Okay.
So would you
we start-
suggest five
Yeah,
minutes?
5
each?
minutes. And we'll start with the folks in the room.
Good morning, Commissioners. My name is Ben O'Brien. I'm the Director of State Policy Analysis with California Life Sciences.
Ben, I hate to ask you
No.
to do this, but could,
Yeah.
and I know that
Sure,
mic is
sure.
really far down. If there's any
Yeah.
way you could lean into it
Okay.
a little bit more, Sarah's going to help you.
What about one of the mics in front, like
There.
in the next row up? We'll put them in the chair.
Oh, my goodness.
I know. We
Whoa.
live in a great. All right, cool. Is that any better or
Yeah,
better or worse?
kind of get close so we
Okay.
can.
Sounds clear? Okay. Okay, yeah, well, as I said, my name is Ben O'Brien. I'm here on behalf of California Life Sciences. We represent over 1,300 organizations across the state's life sciences ecosystem, including biotechnology, pharmaceutical, and medical technology companies, as well as world-class academic research institutions. This morning, I rise to express our concerns regarding the proposed changes to California's antitrust laws outlined in Memo 2025-32 related to the misuse of market power. I just wanted to
a little,
make
a little closer and a little
Oh,
louder.
sorry.
Yeah.
I just wanted to make a couple of points, given the discussion that was already had by the commissioners, kind of noting some of the specific concerns around defining market power in the life sciences. So market power is especially difficult to define in the life sciences, where competition often occurs in evolving modalities, narrow therapeutic areas, and these often necessarily have few players with this pace of rapid innovation, kind of constantly reshaping the market dynamics that are involved in a lot of these rare disease treatment ventures. And so presuming anti-competitive conduct based on some arbitrary thresholds, or we feel arbitrary thresholds written in these options, such as 30% market share, could penalize companies for legitimate success or for investing in areas of unmet medical need. Worse, such standards could deter investment and trigger lawsuits based on normal competitive behavior. I just wanted to outline a quick example. So for instance, a large pharmaceutical company acquires a promising biotech startup that is potentially leading in a rare disease drug development. So this biotech then acquires this company in order to expand their specific segment of a gene therapy treatment field. This small biotech company often has limited options under when they're still in the development phase without a deal with a larger player in the market. Under either option 1 or 2 related to the misuse of market power, this conduct could be presumed unlawful as an unlawful misuse of market power, either if the pharmaceutical company is very large or has over 30% of whatever gene therapy market is defined by the enforcers. So again, just highlighting, often these markets are narrow by nature, and this type of kind of thresholding could kind of inherently capture some of those behaviors. Again, because of the difficulty in accurately predicting some of these rapidly changing market segments, we would just caution commissioners and kind of wanting to note, particularly in defining market power and establishing some of these standards, these important considerations from the life sciences. We feel that transactions can already be reviewed under existing antitrust laws and assessed under existing standards. There's no need to add an increased risk associated with an alleged misuse of market power, especially with a potential built-in presumption. So just wanted to share those concerns at this time related to those proposals. Thank you.
Okay, thank you. Any questions or comments from members? Hearing none? Thank you.
Good morning.
Good morning.
Andrea Orden on behalf of UFCW and Western States Council, speaking only at this time to Memorandum 2025-43. As you will see, we have been a part of the various coalitions recommending strongly that we do have market power in, particularly for today, in the single firm conduct portion. I'm not exactly sure, Commissioner, what spiking means if we spike this portion, but I do believe that there is sufficient debate and sufficient concern that the most important thing is to be assured that when we do discuss the whole proposal, that proposal is deemed by this commission to be ready to go to the legislature. This one obviously has some questions and questions from your extraordinary staff and your consultant. We do particularly believe, however, that it is important in the future, at least in the future, if not immediately, that we have rebuttable presumptions for single firm conduct, which are set out on the last pages of pages 9 and 10. Thank you very much, and I will be returning.
Thank you. Any other comment from in the room with the vast crowd here? Guess not. Folks online. Sarah?
Yes. Bryn O'Neill.
Hi.
Welcome.
Thank you, Chair and Commissioners. I'm Bryn O'Neill, Regulatory Policy Specialist with the California Nurses Association, a labor union representing over 100,000 registered nurses across California. We want to thank the staff for strong recommendations to improve our antitrust laws. We strongly urge the Commission to include a misuse of market power standard in its legislative recommendations. Specifically, we urge you to adopt option 1, which includes a list of presumptively illegal practices for a company with substantial market power, as defined either by market share or market capitalization. Option 2 has the de minimis standard, which may be difficult for a court to implement. Including misuse of market power option 1 would add clarity and predictability to antitrust law. Clear, bright-line ways to demonstrate market power and a list of presumptive illegal conduct allows government enforcers to feel confident bringing cases and aids judges in applying the law. Clarity on what conduct qualifies as a misuse of market power would also deter corporate abuses by corporations with substantial market power. Now, it's important that these behaviors, when used by small firms, could still qualify as anti-competitive conduct, but a presumption will make enforcement easier against the firms with the most power. So we encourage you to vote out a single firm conduct standard today. You're ready on that one, which will come later, and then to continue the misuse of market power discussion. A misuse of market power standard will protect nurses and patients. Over recent decades, corporate conglomeration has resulted in concerning levels of concentration in healthcare services and employer labor markets. As bedside registered nurses, CNA members are acutely concerned about the harm that corporate abuses of market power have on healthcare access and affordability for patients. Anti-competitive behavior in the healthcare sector is a threat to the health and safety of nurses and other healthcare workers and is making our patients sicker. We've submitted additional comments over the past months and recently with other organizations on this topic, as well as the others before you today. Thank you again to the Commission and staff for your ongoing work on this important study.
Thank you. Any comments or questions for Ms. O'Neill? Hearing none, seeing none? Thank you. Next presenter?
Terry Ollie.
Good morning, Chair and Commissioners. This is Terry Oley, the Director of Economic Security California Action. Thank you so much for this hearing and for taking our comments. I just want to really recognize the tremendous effort and work that has gone into getting the Commission to this point in the process. I think hundreds of thousands maybe of pages of public comment and conversation, hours of conversation have brought us to this moment. And so I just want to really recognize the really robust work that's gone into this. I believe we are taking comment just right now on the misuse of market power memo.
Right.
And so I just want to comment on that, which is to echo the points that Bryn O'Neill just made from CNA and say that we really endorse the adoption of a misuse of market power language. So just like first off, and that we endorse option 1 for all the reasons that Bryn outlined. And I don't think I need to list them out. I would just echo and kind of incorporate by reference everything that she just said. I will also say, though, importantly, that I do understand that perhaps some more discussion needs to happen around the misuse of market power standard, and would strongly encourage you to, if that requires more public comment and more consideration and being taken up at the meeting in December, that seems understandable, but would really urge you to separate that out from the single firm conduct, the opportunity to act on single firm conduct today. These things can be easily separated, and really would urge you to do so. And I can comment further on that later. Thank you so much.
Thank you. Any questions for Ms. Olin? No? Thank you so much. Next comment would be
Ron Knox.
Thank you so much. Thank you, Chair. Thank you, Commissioners. My name is Ron Knox. I'm a senior researcher and an advocate at the Institute for Local Self-Reliance, where for the past several years, I've worked with state lawmakers and officials and allies around the country to help institute antitrust laws and policies that better support working families and small businesses and communities. I appreciate all the work that the commissioners and staff have done on this crucial study of how to improve and strengthen the Cartwright Act. We believe that staff's misuse of market power option 1 would greatly improve the Cartwright Act by adding a non-exhaustive list of presumptively illegal practices for a company with substantial market power, and by offering 2 ways to define that market power via either market share or net sales and market capitalization. By listing such presumptive illegal conduct and clear, bright line ways to demonstrate that power, option 1 would provide useful clarity to prosecutors, judges, and the private sector alike. Not only would such clarity help to streamline the prosecution of anti-competitive corporate abuses, it would also act as a strong deterrent for corporations with substantial market power, helping to prevent abuses and pushing markets towards deconcentration, which I think is a good goal of any kind of law like this. I just want to really quickly respond to something that was said a little earlier. This not in staff's recommendations, and certainly not in my comments. Am I proposing something that would punish the ability for a corporation to be big, on the merits, right? That's not what we're doing here, but it is important to recognize that some corporations in industries have power. And when they have that power, there is the opportunity to abuse that power in ways that harm the competitive process and competitors and consumers and everybody else. The thing that misuse of market power does as a standard is, it simply clarifies which companies, how to prove which companies have that power in that market. And then it sets a list, again, a non-exhaustive list of the kind of core monopolization crimes that often harm competition and the competitive process when they are done by one of those companies with power in that market. It simply adds a lot of clarity and guardrails to the law It makes things extraordinarily clear for judges and for prosecutors and defendants. And again, it makes markets work better, which is, I think, the goal of this entire study. So I have some things to say about single firm conduct, but I'll save those for later. Thank you for your time.
Okay, are there questions for Mr. Knox? I guess I just have one, if you're still there. If I understand what Commissioner Carrillo was suggesting, was moving that list, non-exclusive list of anti-competitive conduct to potentially to single firm and maybe even to mergers, the merger law. And that would make those kinds of conduct potentially illegal, whether you're big or whether you're small. And so I'm just wondering if the goal of your comments is to have that kind of a list, wouldn't it be better to have those sort of anti-competitive kinds of conduct come under scrutiny by the AG and the courts, whether you're a big company or a small company?
I don't know that it would. The misuse of market power standard doesn't necessarily deal in terms of bigness and smallness. It works in terms of power and which companies within an industry have that power. And the misuse of market power standard really dovetails, which what we would like to see, which is the commission to vote to recommend single firm conduct option 2. And it dovetails with that again by clarifying the kinds of conduct that are presumptively unlawful when done by a company with market power, and ways to define that market power. If you were to simply move the list over to single firm conduct, I think you're missing one of the crucial elements that misuse of market power as a standard really deals with, and that is the element of power. Again, not bigness and not smallness, but which companies have power and what they can and can't do with it. So I think it's important as a standalone measure that really dovetails with single firm conduct.
Okay, any other questions from you all? Hearing none, seeing none. Thank you.
Vidushi Dayal.
Thank you. My name is Vidushi Dayal, and I serve as the Director of Legal Analysis at Chamber of Progress, a center-left tech industry association supporting inclusive innovation. I'm here to respectfully urge the Commission to reconsider its draft provisions. These proposed frameworks would impose sweeping restrictions that risk chilling pro-competitive conduct, deterring innovation, and inflicting significant economic harm across the state. Overbroad restraints of trade chill pro-competitive conduct, and the de minimis language is fatally overbroad. By categorically branding routine, efficiency-enhancing practices such as bundling, loyalty rebates, exclusive deals, self-preferencing as presumptive misuse, once a firm is dominant, it sweeps in exactly the conduct that can benefit consumers through lower prices, better integration, and faster innovation. Loyalty rebates lower costs for price-sensitive families and can spur network effects in various industries, hotels, ride-sharing, retail platforms. Product bundling enhances functionality, can lower transaction costs, and enables platform integration. We see this in software suites and cloud services. Platforms that leverage self-preferencing can offer lower prices and faster performance across products. Homing in a bit more on self-preferencing, I'd like to call your attention to recent developments in the government's case against Google, led by the DOJ, joined by various states, about its search product. This case is currently in the remedy stage, but the court during liability tossed self-preferencing claims and just recently rejected remedy proposals that would target self-preferencing. The court correctly understood that self-preferencing is a widespread practice with pro-competitive efficiencies, and conversely, an imposition of broad blanket bans on self-preferencing would actually distort competition, particularly in rapidly evolving markets like AI. So as written, we believe that this draft is incompatible with California's economic future, its innovation, and we urge the Commission to reject frameworks that come at the expense of consumers and benefits to them. Thank you.
Thank you. And are there questions or comments for Ms. Dial? Hearing none, thank you so much. And who next?
Lee Hepner.
Hello, commissioners. My name is Lee Hepner. I am senior legal counsel at the American Economic Liberties Project. Very grateful to be before the commission once again. Earlier commenters have applauded this commission for its extraordinary work over the course of 3 years now to interrogate and understand the nature of antitrust law as it exists today and the opportunities for reform. And I applaud the commission and its staff for their work in that direction. Another commenter also made the point that I would like to echo, that there is nothing illegal about being big on the merits. And that is not what antitrust law in its current iteration or in the reform proposals before you would affect. What this misuse of market power standard seeks to do is to identify conduct that constitutes a misuse of that market power. And I would also, in that same breath, say that the conduct specified in the misuse of market power principle, misuse of market power proposal, is conduct that has long been understood to violate the antitrust laws. Anyone who would characterize either of the proposals on misuse of market power as anything but a moderate and benign codification of longstanding antitrust principles should be cause for concern. And I think that there's a lot of value in codifying these benign, moderate principles for the sake of providing clarity and stability to markets, for the ongoing justiciability and enforceability of antitrust law, which is being eroded at the federal and state level across the country. I joined several of my colleagues in support of option 1, which I again think reflects a very benign codification of longstanding antitrust principles related to bundling, tying, self-preferencing. The citations in staff's report are indicative of the extensive study that has gone into these proposals in recent years, but also building on a century of deep understanding of how the antitrust laws are designed to operate. So I would encourage this commission not to delay here, to recommend option 1. And to the extent that there's concern about whether option 1 on misuse of market power is consistent or can be married with the single firm conduct standard, also before the commission today, I would suggest that it is the role of the legislature to marry these conceptual recommendations. And several of us are preparing for an exhaustive legislative cycle where that is going to take place based on the commission's recommendations and also outside of the commission's recommendations as a normal part of the legislative process. Finally, one commenter said that this could chill pro-competitive conduct. Absolutely not. It is a deeply concerning comment. In fact, the proposal before you, in fact, allows for consideration of pro-competitive effects. That is a very deferential standard for entities who are accused of violating the antitrust laws. So this would not chill pro-competitive conduct. In fact, it would direct courts to consider the pro-competitive effects, even if the presumption of a misuse of market power is met. At risk of being crass, I would ask these commissioners to interrogate who is funding these opposition comments. And you know, I have flagged a couple of commenters so far who are being funded by the very entities who are facing litigation across the country, federally and in California, for violating the antitrust laws. Holding the Google search remedy up as a success story rather than as the need and the basis for reform of our antitrust laws is deeply misleading. And that is an opinion that has attracted round rebuke for its timidity and erosion of antitrust principles. So I would ask that this commission take the moderate step of endorsing option 1 on misuse of market power and allow the legislature to do the hard work of navigating the politics of these proposals going forward. Thank you.
Thank you. Any questions or comments for Mr. Hepner? Hearing none, seeing none. Thank you. Other public comment?
Sedalia King.
Okay.
Thank you, Chair and Honorable Commissioners. My name is Sedalia King with UDW ASME Local 3930. We represent over 220,000 caregivers across California, and many of them are low-income workers who are the most impacted by uncompetitive behavior. Also want to note that we have submitted our written public comments, and I just wanted to provide like a brief touch point on some of them with respect to the merger recommendations. So we urge the commission to reject option 1, which merely replicates the Clayton Act and imports decades of failed federal precedent. Instead, California should adopt a stronger path by combining the best elements of options 2, 3, and 4. The Philadelphia National Bank presumption, baseline thresholds from the 2023 guidelines, and the appreciable risk test.
Ms. King, I think you're on the mergers and acquisitions, and at the moment, we're just talking about the misuse of market power, but we will give the opportunity for public comment on all those at that time. Is that okay?
Yeah, totally. Forgive my mistake.
No problem. So did you have comments on the misuse of market power issue?
I do.
Okay.
So let me find my spot here. Sorry, I've merged them all together in one note section.
That's okay. Take your time.
You know what? Actually, let me pause. I'll come back later on today and I'll complete my comments, but thank you.
Okay, that's fine. We'll see you a little later then.
Jen Suh.
Hi, thank you to the Commission and CLRC staff for your commitment to this critical ongoing work to modernize and strengthen state antitrust law. My name is Jennifer Suh, and I'm speaking on behalf of the Writers Guild of America West, a labor union based in Los Angeles that represents more than 10,000 writers of movies, television, and streaming series in California's vital media and entertainment industry. In addition to the letter we've submitted for the record, we're pleased to address the Commission today about the state of consolidation in our industry and share our recommendations in response to the recent staff memos on single firm conduct, merger provisions, and the misuse of market power. But I'll keep my comments short and focused on the misuse of market power for now.
Great, thank you.
Yeah. Along with representatives from a number of organizations, including CNA, ESCA, ILSR, the Teamsters, UFCW, and ALP, the Writers Guild of America West supports option 1, which presents a strong legal standard and includes a non-exhaustive list of clear, bright line practices that would be considered presumptively legal for a company with substantial market power. This clarity would benefit prosecutors and judges, deter anti-competitive behavior, and streamline the prosecution of anti-competitive behavior, creating healthier markets and economies in California. We look forward to engaging further on this topic and others, and will continue providing feedback to the Commission. Thank you for your time.
Thank you. And you have another one?
Final comment is from Robert Harrell.
Yes, hello. Good morning, commissioners. My name is Robert Harrell, and I am the Executive Director of the Consumer Federation of California. We are a statewide consumer rights and consumer protection organization. And we work on a wide range of consumer issues, including many of the issues that you're speaking about today on part of the agenda. I want to thank the commissioners and particularly your staff for the extensive work that has occurred in this space. I know the work is not quite done yet, although I'll get to that in a second. But you scrambled the agenda a little bit, so I'm just going to focus for these comments on misuse of market power and briefly say that the Consumer Federation of California supports option one with delineating a sort of market power standard. Remember, that's a rebuttable presumption, basically. And if anybody has been following this area over the last number of years, and I know now you all have, you know that every presumption made has certainly been rebutted by large corporations that want to argue that they're not abusing market power. So it's a non-exhaustive list. I'm a big fan of including but not limited to kind of lists personally. But I think it's a very important step that the commission should take. Again, that's based on conduct and actions. And I would just note, it's not about whether a company is necessarily big or small. But what we've seen historically is these kinds of abusive behaviors have been done by larger corporations. You're not reinventing the wheel here. I think you heard Lee and maybe other speakers talk about this. This is pretty mild stuff. You're not rocket science. This is a generally accepted kinds of behavior that is not okay and winds up harming consumers, hurting market competition, and it violates some of the principles of competition in the marketplace that goes back to many authors, none the least of which is Adam Smith in The Wealth of Nations, if you want to start quoting that era and Federalist Papers and things like that. The last thing I would just note is that be wary whenever someone uses the trite phrase, something's going to stifle innovation. Because what I have found in my experience is that many of those who scream the loudest about don't stifle innovation are those who maybe had been innovators in the past, but once they reached a certain market size and market share, they began to actively thwart innovation and competition to protect their turf. So always be aware of that. I will, if available, have other comments later on about some of the other items on your agenda, but that's what the Consumer Federation of California has to say about the misuse of market power standard. I thank you for the time. Appreciate the work.
Thank you, Robert. That's all the online folks. And there was one person who came in a little late. I didn't know if she had a comment on this, but when we asked for comments from the folks in present, you weren't here. So I just want to give you the opportunity. If you had comments on misuse of market power, you're more than welcome to make comments now. Well, if you have information or thoughts to share with us about the misuse of market power, because that's the piece we're doing right now, we probably best to hear at least what thoughts you have on that issue now. Okay. Thank you. All right. So we've heard the comments. There was a suggestion from Commissioner Carrillo a little earlier. Thoughts or comments from commission members about sort of where we might go from here? Yeah, Maria?
I like Commissioner Carrillo's suggestion, and I agree with it. And I'll note that the working group on single firm conduct, they recommended providing guidance to the court by describing a number of modes of single firm conduct that can be anti-competitive depending on the circumstances. So I do think it makes sense to, when we get to single firm conduct, consider adding the
Import,
list.
yeah.
Yeah.
Okay. All right. Other comments? Victor, you're reaching for your microphone, I can tell.
Okay, yeah, I agree with that interpretation and Professor Carrillo's arguments are very sound to me. And again, let me interject a favorite theme of mine, which is I want to see the legislation get passed. And if we go around making more unnecessary or arguably unnecessary provisions, that just makes it more complex and more likely to be criticized and less likely to pass. That's sort of my main theme, as you've heard from many meetings. I'm all aboard with reforming antitrust law, but I want to make sure we get past the finish line rather than to spend years writing something that will be dead on arrival at the legislature.
Got it. Okay, thank you. Any others? Okay, is there a motion? Yeah, okay. Oh, I'm sorry. Yes,
I'm sorry, we had various decision points
yeah.
in the memo, so it probably would be best to go
Well,
through
before we do
that. Yes.
So on this study memo 25-32, my motion would be that the commission not proceed further with this memo.
25-43.
43, sorry.
Yeah.
Yeah. Yeah, so the draft language on misuse of market power, but it sounds like the consensus among the commissioners is that the numbered 1 through 8 list from subdivision A in option 1 or its subdivision B in option 2, that we're going to cut and paste that probably somewhere else.
Imported into, well, yeah.
Yeah, probably single firm conduct. So my motion is that the commission not move forward with misuse of market power with this particular memo. But we're probably going to wind up using the language later.
Okay,
So with that understanding, that's my motion.
but that's, okay, we all understand the motion. Is there a second to that motion?
I'll second.
Moved and seconded. Any other comments or questions by commissioners? Hearing none, seeing none. Would you call the roll?
Yes, I will. Thank you. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Ebner,
Having unavoidably missed the last meeting and being most concerned about the entire package, I'm not prepared at this moment to vote to exclude an option, so I abstain on this.
Okay,
Commissioner Jenkins,
I also abstain.
Commissioner King,
Aye.
Commissioner Simpson.
aye. And we will put this vote on call because we may be joined at some point later today.
I believe Senator Blakespear has joined.
I'm sorry?
I believe Senator Blakespear has joined.
Oh, has joined? Okay. Let's see, we can,
I'm going to abstain on this.
Senator, you're going to abstain?
So
Okay.
Yes.
staff would just,
Okay, wanted to double check, make sure we heard it correctly. Welcome, by the way.
Thank you. Thank you.
Hope you're enjoying your time off.
It's not quite off, but yes, I do.
Yeah,
It is
yeah.
nice not to be in Sacramento. It is true.
Got it. Okay.
and staff would just like to note for the record that Senator Blakespear has now joined. So that brings us to a total of, I believe, 7 commissioners who are present for this vote. And I believe that we have 4 in favor and 3 abstaining.
Okay, so we won't put this on call and that motion has passed then, correct?
Yes,
We have a majority of those present
in voting,
and
yeah.
voting. So the motion has been approved.
So given that direction from the commission, and thank you, it does sound like we'll need to have further discussion in the context of single firm conduct and perhaps mergers, so we can get to that when we get to those
Okay.
memos. And I will
Okay.
note that it is 11:49.
Anybody hungry? As lunch? arrive?
We're going to double check on whether lunch has arrived, but it looks like the next one up on the agenda will be single firm conduct for folks in the meeting room and folks online. I would like to note that we did mention that we received a couple of public comments just this morning. They, we have now posted them to our public database of public comments. So they are available, if anybody would like to look at them. And I believe we had, a copy for the public here as well.
Okay.
And I believe that lunch is ready. Is that correct, Sarah?
Okay, we're just a few minutes before noon, so why don't we recess for lunch for, what do you think? 45 minutes? 45 minutes roughly? Okay, so reconvene at whatever that be, 12:35, give or take. 12:45?
12:45?
Oh, that's an hour. Okay, 12:35. All right. Thank you.
Thank you.
Okay, the hour of 12:35 having arrived and gone. We're back in session. Just to, I will note, Commissioner Jenkins had other commitments for this afternoon. She will not be with us this afternoon. But we still have a quorum. So I think the next item on the agenda is single firm conduct.
Yes, it is. Would you like me to proceed?
Yes, please.
Okay, so like we did on the last item, the staff will go through the whole memo
Mhm.
and then we'll take public comment and then we'll revisit.
Great, thank you.
So at the last meeting, at our June meeting of the commission did give staff some specific direction on things to tweak in the language that was before it. So we've endeavored to do that in this memorandum. You can see that on pages 1 and 2 for reference. We also received a number of additional public comments, so we will be including that in our discussion as well. We have
Okay.
public comments from the Economic Security, California Action, and several other entities, the International Brotherhood of Teamsters and other labor organizations, the Internet Accountability Project, the Office of Kat Taylor, Cameo Network, Jordan Cunningham, and the last one we got is in the supplemental memo, which is from the Writers Guild of America West.
Okay.
So before we get into the specifics of the language, we did receive a number of public comments, basically asking the commission to move forward with the single firm conduct recommendations, the portion of that study. As you can see in the memorandum on pages 5 and 6, I believe,
Mhm.
a number of organizations said, please commission approve something at the September 18th meeting.
Right.
In that context, the commission had previously decided to move forward very, very early on with the recommendation to encompass the whole antitrust study. Of note, I would say former Assembly Member Cunningham, who was one of the authors of the ACR 95, the resolution directing the commission to conduct this study, had initially urged the commission to move forward with it as a package, but has subsequently joined with others in asking the commission to sort of split off single firm conduct and move forward with that one. So the question before the commission, which we'll take up after public comment, but does the commission wish to direct staff to continue to work on the single firm conduct draft language recommendation as the first in the sequence of the recommendations on the antitrust study without deciding on whether other topics will be treated in separate sequences at this time? The commission could, that's how we frame the question, but if the commission wanted to say, let's make single firm conduct the first priority, then staff, we want you to turn to mergers as the second priority, the commission could certainly do that.
So just to make sure I'm understanding it, early on in the study, what, 2 years ago now? Early on, we decided that all of the topics would be merged and it would be one big recommendation with all those topics. There are suggestions from public comment and including Cunningham, who was one of the co-authors, to rather than doing that and waiting till you finish all of the issues before sending us anything, to perhaps take, including like single firm conduct, do your recommendation on single firm conduct and approve that and send that to us first, and then in sequence others. So what do members think about that? I mean, I'm kind of inclined to do that, to get some of these off the table and to the legislature. But I'd be interested in comments.
I'd be interested in that too, as long as there's no overlap or relationship between the remaining proposals we need to review, which I guess would just be the mergers and acquisition.
Probably so, although I think there were some other.
There were some other
topics.
laundry list
Yeah.
of topics that the commission has not gotten to yet. The staff does believe that single firm conduct could move forward as a single option. Sarah, did you have a comment?
Senator Blakespear also has her hand up.
I'm sorry, say again?
Senator Blakespear also has her hand
Senator
up.
Blakespear.
Mhm.
Yeah. Commissioner Blakespear.
Sorry, yeah, excuse me. It takes me a minute to get unmuted here. Yes, I just wanted to support what you're talking about right now and say that moving forward specifically with or separating out single firm conduct from the rest of these antitrust topics, and then having that basically move forward to the legislature with a recommendation, I think is the right decision here. So, you know, I know we're probably going to take some public comments and but I'll just, since we're talking about it right now, I wanted to weigh in. And then, you know, would be happy to make a motion or to approve someone else's motion to go in that direction when we get to that point. And I think we would need maybe a final recommendation from staff for approval at our next meeting on that. But basically it would be like a revised option 2 with relevant to what we talked about in the previous item. So with the misuse of market power option 1 provisions that were added this morning to come back to us for a final approval. So those are my comments at this point.
So just to add a little bit about the traditional commission process, the way the commission usually approaches things is that if the commission were to get to decisions on single firm conduct today, the next step would be for the staff to approve a tentative recommendation for approval at the December meeting, which would then be circulated for public comment, and then come back to the commission for final approval with consideration of the comments as a final recommendation.
And when would that take place?
That, well, we haven't set the calendar yet for next year, but I think for a study of this size,
Right.
I think typically we would want to give 60 days for public comment on the one hand. On the other hand, we've had robust
Right.
public comment throughout. So it's, possible to do a 30-day public comment if we had a commission meeting earlier in the year.
Okay.
We could have perhaps something approved in the winter, in the earlier months of,
We're scheduled for a meeting in December, right?
Right, for like the 1st or 2nd of
Fourth.
December.
The 4th.
So we could do conceivably a meeting in January to.
Yeah, I would
You know,
very
you-
much support that because I think we do want to leave time for the legislature. We want the legislature to be able to take action in 2026 and not have to wait until the 2027
Right.
year, especially just given that we have had, 8 working group meetings and we've had many detailed reports and many
Right.
opportunities since 2022 when this was first authorized by the legislature. So yeah, I think I would be definitely in favor of the 30-day comment period and also just trying to expedite getting at least this one section to move forward.
Is it possible to put this on for our December meeting? Or is that too soon?
Well, I think as Sharon was saying, if we go through and make decisions on what a single firm conduct recommendation ought to look like, the staff could put it together as a tentative recommendation for December. And then we would have public comment, and potentially in January, pick it up as a final recommendation. Victor?
Yeah, I understand the spirit of this proposal, and I haven't made up my mind yet. Because there's kind of an underlying presumption that we're gonna get this thing passed.
Well,
And I can see scenarios where the forces of lobbying are unleashed and doesn't get this passed. And then there'll be implications or threats or insinuations about how the rest of the study should go. So I won't wait for public comment before I make up my mind on this point. But I understand that it sounds nice that we would have one section, we tender it up. There seems to be broad agreement on the option 2 and to get it done, and then we'd have something accomplished. But should this fail,
when you say fail, you mean fail by the commission or fail by the legislature?
fail by the legislature.
Because that wouldn't happen until, mid to late.
So
next
you're
year.
saying this is just giving it to them so that they could start their process?
Right.
Okay,
Exactly.
so how would the votes go, though? Would it be voted on separately from the rest of the package, or?
Yes,
So it'd be voted on months before the other provisions?
right. Senator Blakespear?
Yeah, I was just going to say that I think the role of the commission is to do our job as the Law Revision Commission and pass it on to the legislature, and then it's out of our hands. And so anybody who disagrees with option 2 can be heavily involved in the legislative process. All of the meeting with lawmakers and testifying at committee hearings and negotiating amendments. I mean, all that will take place after us. So I think we'll have separated this one thing out, the revised option 2, and then the rest of the things can continue to be discussed and by the Law Revision Commission, but at least something will move forward. Because I do think the legislature is waiting to see what comes out of this commission because there's been so much work done. So getting something, moving, especially just recognizing how many years it's already been since the legislature gave this to the commission in 2022. So, I just think we should try to get something out.
Okay, well, now you're illuminating me about the process. I was just concerned that the voting on the first portion will somehow affect our work on the rest. But it sounds like timing wise, that probably won't be a problem. Okay,
I would think so.
thank you.
Okay. Any other comments by members on process? Do we take public comment on that? Or,
we were going to reserve it until I get through the entire memo.
okay.
Okay, so the first substantive thing on the commission's agenda is looking at option one, the basic single firm conduct provision. As a reminder, this option uses language similar to Sherman Act Section 2. You have seen this language before. At prior commission meetings, several commissioners suggested dispensing with the option due to its close alignment with existing federal antitrust and the desire to make sure that California has sort of a standalone single firm conduct provision that can be federal law could certainly be considered, but wouldn't be binding. One of the commissioners suggested that option one could be viable if it were coupled with statements rejecting specific elements of federal precedents, and also again saying that the California courts were not necessarily bound by the federal precedent. We think that so if the commission did decide to go with option one, the staff does recommend that the commission include one or more of the what we're calling for now the legislative findings and declarations that are included in the memorandum. I also want to note that the commission has not received any public comment in support of option one. In contrast, several commenters expressed significant concern about option one, even if it was coupled with the statements distancing it from federal law. And there's certainly organizations that would oppose, I think, option one when it's coupled with the findings and declarations that they're concerned about. So the question before the commission is, would the commission like the staff to make revisions or conduct further analysis of this option, or would the commission like to adopt option one, or would the commission like to direct the staff to discontinue work on this option?
Okay, and now it'd be appropriate to take public comment?
No, we're gonna
No.
wait till the end of the
The end of the
memo.
memo, okay.
And,
Okay, that's,
but we would
that's-
like to hear comments from commissioners.
okay. David,
I suggest that we move on from option one and consider only option two with amendments to be determined.
okay. Other members?
I felt that way at past meetings, and so yes, I'm in favor of abandoning option one.
Got it. Maria? Agree? Yeah, I concur too. I mean, notwithstanding what one might write in findings and declarations, it seems to me it'd be, if the, one of the underlying purposes is to have a California law that doesn't necessarily mirror federal law, and even if you say in findings and declarations that you know, why would you write a California law that is the same as a federal law if you didn't want courts to come to the same conclusions about cases and issues? So I tend to agree that this is not a place where we're likely to go. Other members, commission members?
I
Is there-
agree. I
Okay.
agree. Yeah.
Thank you. Is
Agreed.
Ambassador, there he is. Okay. There
Yeah.
he is. Okay. So next issue?
Okay, so the next one is a revised option to the enhanced single firm conduct provisions. You've seen this language before. We do, in response to the commission's directions, we've have made some revisions. Just to summarize, it includes the basic single firm conduct provision that's presented in option one, but it also combines it with prohibitions on restraint of trade, a phrase used in both the Cartwright Act and the Sherman Act. And the language that you've been considering to date is on page 8 The staff would like to note that option 2 is the only option that has received public comments in support. Most recently, the Teamsters and their partners and other organizations endorsed option 2, although they have made some suggestions, which we will highlight as we move forward with this. So going back to commission comments, in response to public comments concerned that the term restraint of trade is too vague, the commission directed staff to suggest language clarifying that the section applies to unreasonable restraints of trade that could be accomplished in subdivision C. If the commission adopts that new subdivision, a commission comment could explain that this language is intended to codify the California Supreme Court's holding in re Cipro 1 and 2. Alternatively, the commission could consider whether adding this language to the statute might suggest the intent to create a new standard, and that's because the term restraint of trade is widely considered as unreasonable restraint of trade in the case law. So another way to approach this is that rather than putting it in the statute itself and perhaps raising questions about, is this a new standard, is that there could be a commission comment that explains that restraint of trade is understood to be the term as construed by case law as unreasonable. And at this point, I'm going to ask Cheryl if she has anything to add.
Yes. No, I think that kind of covers it. I don't know about the comment as opposed to putting it in the preamble.
Could I ask a
Yeah.
question of my colleagues, either the senator or the viceroy or both, from a legislative drafting standpoint? Like, it seems to me whether we put the term unreasonable in the text of the statute or not, either way, we have to do a comment that explains
That's correct.
whether this is intended to be a departure from existing law and it's the new standard, or if we're just essentially codifying existing case law. I think we have to explain it either way. If it seems to me like if our intention is to import the in re Cipro unreasonable restraint gloss on previous statutory text, we might as well just say that in the text. And then in the comments say, this is not meant to add anything new. We're just codifying existing case law. But I defer to my colleagues who have more drafting experience than me.
I think more clarity is better. So if we don't mean to add anything and stating that, then that's a good idea.
But would you put unreasonable in the statutory text, or just leave it bare and say restraint of trade, and then in the comments say this is meant to only cover unreasonable restraints of trade?
I don't think it matters. I think as long as it's clear what the intent is, then the legislature will do what it wants with it.
My instinct would actually be to put, rather than have like a subdivision C that it even though it's in statute, expresses the intent, I would put the unreasonable up in subdivision A and or B to, because what courts will be litigating is the law, the statute. And they can look at whatever they want to or not, or choose not to get, well, what did they mean by this? But it seems to me that if you put it in the operative statute and not in a finding or a comment or something, that's what's going to drive a judge's decision on how to interpret the.
So you'd put it in A1.
I would have put it in A1 and B, as used in this section, unreasonable restraint of trade shall not include.
Yeah.
Include, yeah.
Okay. So then I had another legislative drafting question. So we have sort of floating our cut and paste bit of text from the market dominance thing from this morning. It's the eight numbered list of examples of things that are a non-exclusive list of unreasonable restraints of trade. Would you paste that in here somewhere?
Well, I don't know. I mean, my question is, in the misuse of market power, whether those are, I was sort of thinking about this at lunch, whether those are behaviors that are legal, currently legal when you're a small firm, but may or may not be legal when you're a big firm, depending on, you know, who benefits and who's hurt by it. If they are behaviors that could be illegal for you know, medium-sized and small firms as well, then they probably ought to go under the section, what, 16.720, where there's the list, that's the list of actions, I think, in the existing Cartwright Act. So I'm not sure about that, honestly.
And I think we can talk about that a little bit more when we get to the findings and declarations part of
Right.
the recommendation on single firm conduct, because as Commissioner Bean noticed, the single firm conduct working group had made a number of recommendations to highlight certain conduct that court should perhaps view with skepticism and separate California from being bound by federal precedent. So
So I guess that leaves me with a broader question, like not just a drafting technical question, but you know, what's the sense of my colleagues that list of 8 numbered specific examples? It seems to me like that should go in here somewhere. Do folks concur? As a non-exclusive list of examples of the kinds of things that would be unreasonable in restraints of trade.
Commission members?
I'd agree with that observation, yeah.
Okay.
We talked extensively when we decided not to go with that we would move it. So I think it should be moved but I still am waiting to hear where.
Yeah. Maria?
Somewhere in here.
No, I agree also. I'm not a drafting specialist, so I have no idea.
Senator Blakespear, are you still with us? Any thoughts?
Oh, Commissioner?
I don't have any
Sarah?
thoughts on this.
Okay, thank you. Sharon, Sarah.
Yes, please. In revised option 2, in subdivision B, it does refer to restraint of trade as all of the actions that are included in existing 16.720 in the Business and Professions Code. So 16.720, I don't know how we can get there, but it does make a list of different behaviors, including carrying out restrictions in trade or commerce, limit or reducing the production or increase in price of merchandise or of any commodity. So there is a list in current law that comprehensive of the ones in that previous list. But this could also be a place where you could choose to amend if you'd like.
Is the list in 16.720 the same or substantially the same as the 8 numbered list that we have on the clipboard?
I would argue that you could read into 16.720 all of those behaviors if they were done to restrict trade.
Okay.
So I'm gonna insert myself here. The conduct that was listed in the abuse of dominance provision that you had this morning is conduct that is typically considered possibly pro-competitive, but it can be anti-competitive when done by an entity with me. But a lot of companies, I mean, pricing, doing the kinds of things that were listed in the abuse of dominance. So we're not, I think, with single conduct, this applies to everybody. And so that kind of conduct that you saw in that list this morning wouldn't apply to everybody. It only applies to those who have substantial market. And the listing of conduct under 16720, it doesn't list specific kind of conduct. It talks about whether it restrains the price, whether it canoodles the price, whether it fixes the price. It has a lot of different words to talk about conduct that interferes with price and output, but it doesn't mention specific kinds of conduct like self-preferencing or bundling or exclusionary conduct. So
So it-
kind of apples and oranges there.
So it mentions the outcome of the conduct, not the conduct itself.
Precisely.
Okay.
I think that's the meaning or the intention that I was going for, because I can see how specific acts would be proper competitive activity if done by a small player, but they would be improper anti-competitive activity if done by a large player. So I think I agree with you and what Rick just said, that it's not so much the conduct, it's the effect on competition in the marketplace. So that kind of backs us into that distinction we were trying to draw with the large market players, because it matters who does it, and who does it has an effect on competition.
Well, is that the kind of trade-off that a court would adjudicate? That is, if there's conduct that, I don't know what it would be, self-preferencing or something like that, that someone could argue, well, it may not be illegal by a small firm, but in the circumstances, in this case, it was done by a big firm, and it's clear that in this particular circumstance, in this case, the harm to competition and whoever is outweighs the potential benefit. I mean, is that the kind of thing that
Yes, Commissioner, Chair? Yes, that's exactly, that would be the current situation.
That's called the rule of reason, and that's why antitrust cases are so about the competitive effects of their conduct. One saying it doesn't have much effect, and the other saying it's very harmful, and then at the whole context of the behavior.
That seems unavoidable.
I'm sorry?
It seems unavoidable, like through the changes that we're talking about making. Like the only way to avoid that practical effect is to go with something like a bright line rule or a hard presumption, which it sounds like we're not interested in doing.
Right.
So people are going to be stuck with that, unfortunately. You're still going to have to figure that out.
So does that imply, oh, I'm sorry, Maria? I was going to say, does that imply that we may not want to import that specific list of conduct into single firm? Because that's the actions, as opposed to the 16720 that's in the law now, speaks to the, whatever actions they are, speaks to the effect of those actions on competitors and that sort of thing. I mean, is that functionally what we're thinking?
Sarah, did you want to say something about that?
No, I think that's accurate.
Okay. Maria, anyway,
That
Current,
I put words in your mouth?
that
is
was
it?
basically my
Okay,
question.
right.
so.
Okay,
Okay.
all right. Moving on.
Yeah, so moving on to the next point.
So I'm sorry, one of the questions was, do we do a subdivision C that talks about intent, or, well, we'll have to decide later on, I guess, but, or do we put the unreasonable language up in A and B?
I like that solution.
Yeah. I kind of do too. So anyway, that's something that is a decision point. We'll have to deal with it. Okay.
Okay, so moving on to page 10, the commission directed the staff to do further analysis on the phrase in subdivision A1 as it now reads, stating that it is unlawful to restrain the free exercise of competition or the freedom of trade or production. And upon further research, we concluded that the cited language isn't really necessary, nor does it have precedence in antitrust law. So what we are recommending is that that phrase be stricken, and Commissioner Jenkins is not here, but her astute eye as the legislative council, I think, caught that particular one.
So I'm sorry. And so the suggestion is,
So we would, in subdivision A1, and I understand that we may be revising that to include the term unreasonable, but basically, if you look on page 10, the
Mhm.
language that says, or to attempt to restrain trade,
right,
the free exercise of competition or the freedom of trade or production, that language would be stricken.
okay.
And I will note that the Teamsters and the folks that joined them in their letter also recommended deleting that phrase.
Okay.
Okay, so the Teamsters group and several other organizations suggest the following revisions to subdivision A. They suggest that it be revised to say, I'm sorry, I'm getting a little tripped up here. I don't know if I have the right exact subdivision, but yes, I do. Okay, so that what they're suggesting is that language be added that states it is unlawful for one or more person to act, etc., and then clarifying it whether they are carried out directly or indirectly through another entity or person, such as an independent contractor or intermediary. The staff believes the existing language outlining actions caused or directed captures restraints of trade affected directly or indirectly. So while it could clarify things for companies whose complex organizations and alliances may obscure responsible actors' identity, the staff does not believe it is necessary. Although, and I'm sure the commission is going to be hearing public comment on that and may be persuaded otherwise. So any questions about that?
So that's, and so the staff comment is when it says for one or more person to act, cause, take, or direct measures, actions, or events covers what's suggested in the new underlined.
We believe so.
Yeah, okay. That'd be my instinct as well.
That we're trying to keep things simple.
Simple, right,
I know that's the
The-
direction we've
the KISS,
gotten
the
from the
KISS,
commi-
right, the KISS principle, yeah, okay.
So the Teamsters and their partners also suggested increasing the standard of proof in this section to a clear and convincing rather than the current preponderance of evidence standard. They actually suggested some language about how exactly that would be accomplished, that we would have to revise to get it into California legislative drafting style. But that said, it would require defendants to prove with clear and convincing evidence that any alleged pro-competitive benefits actually justify the anti-competitive conduct. While that addresses concerns that certain antitrust cases may have become prolonged and uncertain because the status quo allows federal judges to accept vaguer claims of pro-competitive benefits is that could be viewed as how the preponderance of the preponderance standard works. In looking at it, the staff believes that clear and convincing is a higher standard than the status quo. A prima facie case under the status quo is generally rebutted by a preponderance of the evidence standard, which means that the evidence in support must merely be greater than the evidence against it. It's a common standard seen in civil actions. However, staff is concerned and would like to bring to the attention of the commission that this would be a new untested standard that could lead to substantial uncertainty. And that could be, I'm sure we'll hear from folks about how that could be problematic in the antitrust litigation situations. So any comments about that?
Yeah, I have a question. So does the Cartwright Act currently, number one, does the Cartwright Act currently explicitly say what's the preponderance?
I don't believe so, but I am going to ask Cheryl because she has everything antitrust memorized. Is that from case law or is that from statute?
I'm sorry, does the Cartwright Act provide for what?
Does the Cartwright Act explicitly say preponderance of the evidence a standard?
The Cartwright Act doesn't, but case law and history is pretty well established. It's a preponderance of the evidence.
And is this I don't know if burden shifting is quite the right term, but
It would dramatically change the burden of proof. It would
Okay.
make it significantly different. This would be a big change.
yeah.
And it's kind of in the zone of,
And it-
of
and it-
Victor's
and it-
concerns about this could be something that kills the whole deal.
And it would have the effect of giving a higher evidence standard for the defendant to prove that the conduct, the good outcomes are better than the bad outcomes, as opposed to the plaintiff having to prove by some one standard.
Like
or the other.
51%.
The opposite. Okay.
It would make it a lot harder to defend these cases.
Yeah. Okay. Other questions or comments by commissioners? Hearing none. Next.
Next, the International Brotherhood of Teamsters and their group also suggests adding language expressly stating that harm to competition in one market may not be offset by purported benefits in a separate market. Their suggested language is on page 11. The staff concluded that the clarification is unnecessary because it restates existing case law on this issue. Any questions? And Cheryl, did you have anything to add on that?
I would add that even though it is supported out of case law, it's another one of those points of annex often ignored by the court.
By federal courts, by state courts.
Well, most antitrust cases are held,
Right.
sometimes follow federal law. Allow parties to argue that the benefits in one market justify harms in another market.
Okay.
Benefits and harms in a.
Okay.
Any more on that one?
Any more? Okay.
Okay, so then the question that I think will be before the commission when the commission revisits option 2 after public comment is, does the commission want more analysis on it, or would the commission like to adopt option 2 with or without changes.
Got it. Okay.
Okay, so moving on to revisions on the findings and declarations / codified intent language. We received some more comments from the Teamsters and their partners, the Cameo Network, and other organizations that encourage the commission to include the draft findings and declarations in its recommendation. We have a quote stating why they believe it's very important. And in response to the direction we received by the commission at the last meeting, we have some suggested revisions, and we also have included summaries of relevant public comments. So for the basic purpose statement, originally we had it in sort of legislative findings and the declarations, but I think at the last meeting, the commission pretty clearly directed staff to codify that statement at the beginning of the Cartwright Act. So that would be a revision to, if the commission decides to adopt option 2, that would be included within option 2, for example. The commission also discussed whether the language the legislature finds and declares should be eliminated. In reviewing the commission meeting, it didn't appear that there was a clear consensus from the commission at that point. So we didn't strike out the legislature finds and declares, but that's certainly something that the commission could do. And I guess from a drafting standpoint, I actually think it would be cleaner to not include that language.
And I think that was my suggestion, and I would concur. It's rather than, well, the legislature thinks we ought to interpret this way. I would say explicitly what in the statute, what the purpose of it is, what the goal of it is, as opposed to, the legislature thinks the goal is this, but if they wanted it, that to be the outcome, they would have drafted differently or something like that. So, I mean, that's my personal view.
Okay, should I move on to
Yeah.
the next one?
Yeah.
Okay, the next one, excuse me, is the enhanced purpose statement. The language that the commission has been considering so far is on pages 13 and 14 of the memorandum. We had made a previous tweak to it based on commission feedback. The commission directed staff to move language in subdivision A to the basic purpose statement and dispense with subdivisions B and D, I believe. In looking at this, again, the staff is recommending the following edits to instead add this as a new subdivision B to the basic purpose statement. So B, as you see on page 14, protecting competition includes protecting competition between businesses when they compete for workers by prohibiting anti-competitive business practice, etc., would be codified along with the basic purpose statement. And per the commission's direction, the rest would be stricken.
Right.
Any comments on that?
Any comments or questions from commissioners? Hearing none? Okay.
Okay, so the next one is the statement reflecting California's laws, preferences, and priorities. I think at one point there was a direction to remove the legislature hereby finds and declare. So what you see on page 14 and 15 is direction is the language that commission considered at its last meeting. And then based on reaction to that, the commission directed further changes, and it believed that subdivisions B and C should be dispensed with, and that staff should include subdivisions A, D, and E in a potentially codified provision to provide directions to the court. That could be included along with the language in the basic purpose statement. So the revisions appear on pages 15, 16, and 17 of the memorandum. In subdivision B, or subdivision A, I'm sorry, there was some discussion at the last meeting about whether the use of the term maximizing was the best use or the appropriate word. Staff again notes that it does appear in the case that we're citing here, Clayworth versus Pfizer. Alternatively, I think Commissioner suggested, I think it was Commissioner Carrillo, suggested moving the language of A into subdivision D, which is basically, a statement about what the California Supreme Court has determined about the Cartwright Act, that it's broader in range and deeper in reach than the Sherman Act. And let me just make sure I'm following along. That the language, basically the language from Clayworth could be imported into subdivision D, and the bracketed language in subdivision D that appears on page 17 without mentioning the name of the case in the statute. The staff also notes that I think pretty much everything that's in subdivision D is drawing from existing case law. So it would be accompanied by a commission comment explaining where that language was derived from. Subdivision B, I believe that commission thought wasn't really adding anything that wasn't already there. And so you can see on page 16, staff has subdivision C appearing in strikeout. Then on subdivision C, the staff is proposing a tweak that is responsive to another comment from the commission that so I think at one point the commission was considering completely deleting subdivision C, but the staff is suggesting the commission could retain portions to recognize that California joins the federal government in recognizing that unilateral action and multi-party actions can interfere with free and trade competition. And that was the reason we're suggesting that is the commission directed staff to include language noting that unilateral and multi-party conduct can result in unfair competition. So that's up for consideration by the commission as well. And then I think I already covered subdivision D, and the commission had several commissioners suggested revising subdivision A. If you look on page 18, we have language that we believe captured the commission's direction, and that this goes to the concept that while federal case law on the subject of this article is not binding on California courts, courts may consider federal case law as persuasive authority to extent they find it consistent with California law, and then we have and section 167XX, but that would again be the basic purpose statement where the legislature would be stating, here's the purpose of the of this article. I think I covered everything in this particular section. Is there questions?
Just a clarifying question for me. The material that's at the top of page 18 starts with federal case law on the subject of this article. Is that in its own subdivision E, or does that get tacked on at the end of D? I don't care one way or the other. But it's not clear to me from the strikeouts, because subdivision E it's tabbed differently, but it's not stricken out. The actual marker for sub E on page 17,
the bottom of 17.
I'm sorry.
just above the footnote break. See the indent for subdivision E.
So on page 17, we strike the language the commission had previously.
Yeah. So the part that's left that we're keeping, where does that go? Does that stay in its own subdivision E, or does that go in D?
It would stay in subdivision E for now. When we get down to consolidating all the commission's decisions into one statutory framework, we might need to play a little bit with subdivisions and all that, but the language that we think is responsive to the commission's direction does appear on page 18.
Other questions? I have one. It wasn't clear to me, because in the top of page 17, the language in brackets is the same as subdivision A above, right? Or almost the same.
Yes.
And where were you suggesting we have that?
It would be in subdivision. So if this commission likes this version, subdivision A would be eliminated.
Okay.
And that language, substantially similar language without stating the case name, would be included in subdivision D where it appears.
Okay. The other question I have is, what does liberally interpret mean? As opposed to court shall interpret California's laws to best promote court shall liberally interpret antitrust laws to promote freedom. What is
So
what does
that-
liberally add?
That is language that is actually from the case, and I might ask Cheryl for help from that. But basically, the direction is that, when in an antitrust case, you shouldn't be taking a narrow interpretation of antitrust laws when you're evaluating whether, what best promotes free and fair competition. And then also followed by be mindful that California favors maximizing effective deterrence in antitrust violations. So I think the California Supreme Court's language is also trying to say, look, California's laws are different from federal law.
Right.
We courts, lower courts, when you're interpreting these and federal courts, because they should be looking to California, how California interprets their own state's law, that we're not looking at it exactly like the federal courts are, that it's a more liberal interpretation, or, that really want to maximize deterrence. And Cheryl, can you help me out a little bit with this one?
I mean, the liberally interpret formula is often used in statute to encourage the court to broadly as possible to achieve. So they're saying in this case, we want you to interpret the antitrust laws as broadly as possible to achieve objective of promoting free and fair. And I know we've talked, I think we've also talked about the maximizing effective deterrence, and we've we went on and on about that for a long time and it kind of isn't it isn't intuitive what it means. But so much of federal law is infected by this thought that they disfavor over deterrence and or under deterrence because the cost of going after a company and tagging them with liability, a quote, false positive, so great. And California has specifically rejected that notion. That's why we talk about, and then the Clayworth case, they talk about the court, state maximizing deterrence as opposed to minimizing deterrence or under deterring antitrust violations.
Okay, I'm still torn on the liberally.
Could I suggest something?
It's
Chair?
pretty common.
Yeah. Is it common?
It's common. Yeah. It's a signal to a court to either read something broadly or narrowly. And some statutes you want to be read narrowly, like murder. You don't want to be over convicting people of murder.
Okay.
Some things you want courts to be more aggressive or liberal in exploring a statute's boundaries. So
Okay.
it'll capture more conduct. Whereas if we use language to signal a narrow reading is intended, it'll
Well, but-
exclude more conduct.
Well, I'm not saying to interpret it narrowly. I'm just wondering if courts shall interpret California's antitrust laws to best promote free and fair competition, as opposed to liberally interpret. So I didn't know if you thought that was a substantive difference. It didn't strike me as it was, but I'm not a lawyer and I don't even play one on TV.
Well, in my view, it signals to the court that we
Okay.
should look at it broadly
Okay.
as opposed to narrowly.
Okay, okay. Sarah?
In other words, if you think it's in there, they will believe it's in there rather than looking for it to be exactly in there.
Okay. The other part I'm still struggling with is, Cheryl mentioned, be mindful that California favors maximizing effective deterrence of antitrust violations. That it makes me feel uncomfortable that courts ought to be interpreting the law, and if they find, based on whether it's preponderance of the evidence or whatever, that a business violated the law and did something that was antithetical to free and fair competition, then they ought to find against it, as opposed to it feels like you're tilting the scale. It feels like you're tilting the scale between innocent and guilty, between you did it and you didn't do it, and that bothers me a little bit. So but you guys know a lot about litigation and I don't, but
To me, I think the difference is, as our learned colleague was saying, it's to both distinguish and signal to the courts that not only read different from federal law, but we take the opposite view of federal law. That federal law is to be read narrowly. At least that's the prevailing view in the courts. Sherman Act should be read narrowly. You should under enforce rather than over enforce if you're going to, because you're going to miss some cases on one side or the other. And the question is whether you're going to be more conservative or liberal, not in the political sense, obviously. And this is a signal to courts that California takes the opposite view, that if we're going to make mistakes, we'd rather over enforce than under enforce.
see, that's what kind of bothers me, because Judge, if you don't know what to do, then lean on the side of going after this defendant. And that bothers me. It's Judge, you ought to make a decision based on the evidence and the whatever, and you shouldn't have the scale implicitly tilted one way. That's what bothers me about it.
So I would, and I'd love to hear more from the other commissioners,
Yeah,
but
yeah, me too.
what what this language does is it's actually from the case law, from a California Supreme Court case. So lower courts, when they're interpreting, how do we apply the Cartwright Act, they should be looking to that direction from the California Supreme Court. So I guess, that this would codify it, but it's already law that is out there. Is that a fair way of saying it?
Another way to think of this is, there's rules like this all over the place. Tie goes to the runner.
Yeah.
That in itself is a judgment call, and it directs the umpire's judgment in a particular direction.
Right.
That when it's kind of even Steven, you'll choose one side over the other. So it is effectively a presumption. It's a weight on the scale if you want to look at it that way. But in close cases, you have to have a direction about who to choose. Otherwise, it's arbitrary.
Well, it does, okay.
And as
well,
Sharon says, that the law already has this
yeah,
rule.
well,
The tie doesn't go to the
Supreme
runner.
Court decision already has it, but
Yeah.
since I'm a legislative guy, I don't pay that much attention to Supreme Court. I mean, since I used to write I would like to write the laws to be, I don't know, to say, not to say what the outcome is, but to have a scale that's even. I don't know.
This does state a philosophy.
Chair,
Go ahead,
would-
Ambassador.
Chair, would you want the commission to overrule a California Supreme Court decision?
Doesn't bother me. Because I used to judge judges, so I'm not scared of judges.
Well, it's
At least
not
I
a matter
wasn't.
of being scared of judges. It's a matter of, do we want to affirmatively alter existing California law?
Well, it makes me uncomfortable. And maybe it's because I don't think of Supreme Court decisions as California law. I think that's stuff I used to write. Anyway, I'll just kind of leave it at that.
Can I make one further
I
point?
share with you the discomfort. Obviously, no one likes to have extreme verbiage that seems to be tipping the hat. But I remember back to what Cheryl has been emphasizing, that the federal courts just keep dismissing everything California
Yeah.
does, period.
Yeah.
Yeah, that's true.
That was the point that I was
It's
gonna
not just a matter of how much fervor our state courts pursue these things, but the state has to put its foot down and tell the federal courts, this is who we are, and this is what our rules say. And when Cheryl made that point in an earlier meeting, that was very persuasive to me, that a lot of what we're doing is trying to tell the federal courts, you need to respect this giant body of law and preferences.
Okay.
That's essentially the point that I was going to make, is that there's a core philosophical question here
Yeah.
about antitrust, and federal courts come down one way,
Right.
and existing California law comes down the other way. And so we've heard a number of public commenters
Mhm.
come in and talk about how frustrated they are that federal courts just ignore that.
Yeah.
And we've had some calls in comments to send a strong signal that reminds everyone, federal courts in particular, like, no, California looks at this kind of thing differently.
Yeah.
So
And-
all we're doing is codifying existing law and sending that signal.
My ignorance about this, but do I recall correctly that there may be cases where federal courts are adjudicating California law?
Yes. Yes.
Okay. Okay.
Frequently.
Okay. Right. Okay. Mm-hmm. Okay. Are California judges, if there's a federal court that adjudicates California law and comes up with some interpretation that is kind of like, the federal interpretation of stuff,
And if
are California courts bound? If California courts then have to adjudicate the same law in a something that's not a class action suit, they're not bound by what the federal courts found, held with respect to California law. Okay.
If I can remind folks to really lean into the mic as you're speaking.
Not
I
on
think-
California law.
Okay, thank you very much.
Okay.
And now back, you had a question for Cheryl. That was a question, right? Or was that?
Yes, that was it. And then I was going to just double check. So the staff draft that starts on page 16, which is, I think, had the.
Yes.
Right. That would begin with what's now in subdivision C. California joins the U.S. Department of that would be the beginning of this section? Because you're
Yes,
talking about.
yes. If
moving that.
the commission wants to move A into
D or whatever.
D, then, and had, directed staff to eliminate B, it would start with what is now C, should become A.
Could we flip that with
And
D?
then another thing for the commission to consider is, do you want it to be preceded with the legislature finds and declares, or should it just be statements?
I would start it with D. I would make D A.
I was going to say the same thing, and I would not include legislature finds and declares. I would start saying the California Supreme Court is just whatever it says.
So are you saying that we should not include C?
No, it's a reordering.
Reordering, yeah.
Just, okay,
moving
that's
D.
fine.
Current D is A.
Yeah, that makes perfect
Probably make
sense.
current E B, and current C becomes, it stays C.
I agree.
Yeah, that makes perfect sense.
Yeah,
in terms
because
of-
those are the primary directions.
Okay. I think we got through that one.
Okay.
So the next one, and before we move to public comment, I want to switch to the supplement to make sure I didn't miss anything. But the next one is the statement clarifying that specific elements of federal precedents are not binding. What the commission has considered to date appears on page 19. This language follows the single firm conduct working group's recommendation to avoid importing particular federal judicial interpretations that are inconsistent with, and that's a quote from them, preserving vigorous competition in California. And at the last meeting, the commission did discuss the language at length. I think initially some of the commissioners thought the language was unnecessary since the more general statement reflecting California's laws and preferences and priorities is already given direction to the courts that they're not bound by federal law when applying or interpreting California law, although they may consider it as persuasive when appropriate. There were also, although I don't think that the draft language includes specific cases, there was some discussion about that because I think the language does, in the previous memorandum, there were 3 cases that were a particular concern to the single firm conduct working group, as that is outlined. We provided, based on commission feedback, an option that could be included as uncodified findings and declarations. It could be findings and declarations that are in statute, up to the commission. But we've tweaked it to, if you see on page 20, is that to clarify that California law does not require a finding of any of the following conduct or elements to establish liability. And also, there was some discussion about whether this would be a non-exclusive list. I think there was a concern that when you start listing things, what does that mean? It includes this, but that mean it excludes other things? I mean, and yeah, under the rules of statutory interpretation, even when you're looking at a non-exclusive list, the courts are gonna look to the list itself to divine what also may be included. So, that's something for the consideration of the commission. There's also a tweak on page 21. And at the last meeting, basically, and it was towards the end of the meeting, I will say that, the commission was sort of on the fence, is like, is this something we want in statute, or maybe we could handle it by a comment? We did suggest some language that could perhaps be in a conduct, but the staff recommends that if the commission wants to do this, it would be better for it to be in statute that more clearly reflects legislative intent and under the rules of statutory construction. What do you look to first?
Right.
You look to what's in statute.
Right.
And then you look for legislative intent. The commission comments are considered legislative intent, but it's not the same as having something in the statute. So the staff would recommend against going down the comment route.
And so what would this is a list of evidence of are these conduct that is in violation of antitrust laws? Or is this evidence that would be used to prove that whatever conduct they had was unlawful?
So this would be direction to a court that anything on this list is not required to establish liability. And the reason the single firm conduct working group recommended language along these lines is again, going back to the discussion of federal courts in interpreting California law, it would give direction that no, you do not need to make a finding. You can, but you're not required to make a finding on any of these when you're looking at California law.
And why would somebody be able to assert that you can't find something in violation of California law unless you make one of these findings?
I'm going to ask Cheryl for a little help on this, because I think it's going to those 3 specific cases that we referenced in the prior memorandum, and not just that, in I think subsequent legal interpretation. So Cheryl, do you want to tackle this one?
Chair, a point of order, please. Certain speakers, there's just dead silence when they're apparently talking into the mic. So all of the public who have dialed in are not hearing what's currently being said.
It might be because I turned my microphone off. Sorry about that. So this list represents kind of a collection of consensus bad rulings from various federal courts that don't necessarily even come from the named decision. Like we often talk about the 3 cases, Trinco, Brook, and Amex. And some of these aspects that are listed here weren't actually decided in those cases, but other cases have said, oh, based on this, we're going to say that you have to have a prior course of dealing, or that y- uh, your conduct makes no economic sense, et cetera. So this is a group of principles of rulings that the single firm conduct group has identified as ones that California law should specifically reject. They're also the same as the principles in a couple of federal legislative bills like Calera, where they seek to kind of make the Clayton Act and Sherman Act more robust. So what this is saying is, look, when you interpret California law, we know there's some federal cases out there. You can find federal cases that say just about everything. But if we're saying that you don't have to require what this particular case required to find liability under California law. You can if you want, but you don't have to.
Okay, David?
So correct me if I'm wrong, but the reason this list is here is because these are acts that federal courts have used to deny liability because these things have not been proved, no antitrust violation. And so what we're trying to say is these are not mandatory elements of proof of an antitrust case. If you find it, great, go ahead and find but if they're absent, you can still go ahead and find an antitrust violation based on other evidence. These are not mandatory conditions precedent. Is that right?
Precisely, and I'd add to that antitrust cases in federal courts often get dismissed on the pleadings. The court will say, well, you haven't pled that these parties couldn't act, that you didn't plead why they didn't act independently. There's various kinds of, or you haven't pled market share, even though there's evidence of the anti-competitive effect. And so this gives the court the comfort of saying, well, you don't necessarily have to plead that. Go ahead and require it later in the case, but we don't want you dismissing various federal court holdings.
So they're not required elements of proof
They're not
to get
required.
past a demur.
Okay, then why is that not covered by the generic statement we've got in there about California courts are not required to rely on the basis on federal jurisprudence?
Because a federal court will use stuff on this list to reject California antitrust claims.
Okay.
Oh, that's one reason in my mind.
Oh, okay. Yeah, it's still,
So it's another one that
weird.
overlaps.
Yeah, it's weird to me to have federal courts adjudicating California law.
They do it all the time, and apparently they do it badly.
Yeah, okay. Okay, what other people's commission members' thoughts about this? Hearing none?
No, I'm in favor of including it for the reasons that Cheryl outlined.
Okay.
And I also think that in addition to the federal courts making bad law in California or based on California law, if there isn't any California law on point and it's in federal court, they may refer to federal law as well, if that makes sense. So if the California courts have not spoken, they'll say, oh, here are these federal courts that say X, Y, and Z, and we don't want them to look at X, Y, and Z.
Okay.
Just to
Yeah,
clarify,
I-
they can look at it, but they're not bound by it.
Right, okay. So yeah, I keep getting, when you say that California law doesn't speak to it, I keep thinking of statute. I don't, sorry. Yeah, I know. Okay. Okay, what else?
So I think we actually made it through everything. And I did take a quick look at the supplement, and I think I already mentioned that the Writers Guild of America West, or maybe I did not, also is urging the commission to adopt option 2.
Got it.
And so you can see that in the first supplement.
Okay.
Could we take 5 before we do public comment?
Yeah, that's a good idea. We'll take 5 minutes stretch and come back in 5 minutes? 10 minutes. How about 10 minutes at quarter after?
At 2:15?
2:15.
Okay, thank
right.
you.
Okay, so we're ready for public comment, and we'll start with folks here in the room. Welcome back.
Thank you. Good afternoon, all. As I think the commission is aware, my name is Eric Ensign. I am an antitrust attorney with the law firm of Kroll and Mooring, and we are proud to represent the California Chamber of Commerce in this matter. Thank you for having us. Thank you for taking our submissions over the last few months. And thank you to the staff for all the work it has done in connection with this study. With that being said, we still have serious concerns about the single firm conduct proposals. Option 2 really is a combination of two distinct antitrust concepts that just through that combination will cause great uncertainty. Option 2 would be the only antitrust law that I'm aware of under which a single firm may be liable for a restraint of trade and multiple firms may be liable for monopolization. As we talked about, I think at our last meeting, restraints of trade have always been analyzed and described by courts as agreements and combinations among multiple firms. And monopolization has always been the complete domination of a market by a single firm. But option 2 does away with both these distinctions and really conflates the two. The bigger concern, I think, is that option 2 doesn't provide guidance to courts or businesses as to what an unlawful single firm restraint of trade is. Option 2, of course, as we talked about earlier, it does say that a restraint of trade includes the conduct listed in section 16720 of the existing Cartwright Act. But all of the conduct, and to be clear, it is a list of specific conduct that is unlawful under the Cartwright Act. All of that conduct contemplates joint conduct by multiple entities, not any single firm conduct. So section 16720, for example, says that a restraint of trade is, quote, a combination of capital, skill, or acts by two or more persons to do things like limit or reduce production, increase the price of merchandise, fix any standard or price, and really so on. Nowhere does that statute explain what a single firm restraint of trade is. And it has always been legal for single firms to engage in the conduct listed in section 16720. So single firms, of course, can decide to limit or reduce their own production. Firms may unilaterally, choose to increase the price of merchandise, and firms can unilaterally decide to set their own prices. So option 2 and the reference to section 16720 begs the question, what is lawful and what is unlawful single firm conduct? The uncertainty is really made worse, I think, by the proposed statement clarifying that specific elements of federal precedents are not binding. To be clear, this is not simply a statement that federal precedent is not binding on California courts. It is a statement expressly telling California courts that certain antitrust standards created over roughly the last 130 years are just not required in California. And I think we can debate whether certain Supreme Court decisions are in line with California interests, but rejecting a laundry list of federal standards is dangerous, and it removes really any important standards that have guided courts and businesses over the last several decades. And I think it's also really important to point out, Clayworth versus Pfizer is a great example of it. The California Supreme Court has always said that federal precedent, federal decisions are important in evaluating issues under the Cartwright Act. And in many cases, the California Supreme Court has expressly adopted federal precedents for use here in California. So our view is we have to continue to allow California courts to do this kind of in-depth and case-specific analysis as to what our standards will be here in California. The list that is the list of standards and cases that is specifically called out in the proposal is a rejection of those standards. A LA Superior Court judge is not going to create a standard or enforce a standard that a statute tells the judge does not exist. And I will close with this. The commission, and really Commissioner King reiterated this morning, has repeatedly said that it wants a passable bill. And we completely agree with that. We believe that after all this work, we should be putting forward a passable bill, if any bill at all. This proposal, in my view, is not passable. The last legislative session saw, I think, the most antitrust-related bills ever. There was a significant number of them. Virtually all of them did not pass. And they didn't pass out of concerns of uncertainty and negative impacts on competition. Those same concerns abound with option 2. And for that reason, we request that the commission not adopt that proposal. And I'm happy to answer any questions you might have. Thank you for your time.
Questions or comments from commissioners? I guess my question is, so do you think California should have a law on single firm conduct?
I don't know the answer to that question. I don't. And the reason I don't know the answer to that question is I don't think it's been studied whether California needs its own law on single firm conduct. As we've talked about before, California AG and California private attorneys use Section 2 of the Federal Sherman Act all the time, and they do it with great success. I have not seen a study that says that California is less competitive or that consumers in California are paying more than they should because California does not have a single firm conduct statute. So should we have one? I don't know. I think that needs to be studied. And that's the point we've been making for the last 2 years, is that to do that real analysis, first you have to demonstrate a need. And we don't think a need has been demonstrated.
Okay, I think that's not consistent with our single firm working group, if I remember correctly. Yeah, yeah. Okay.
I'm sorry, I didn't. I
Oh,
couldn't.
sorry. I think our single firm working group came to the opposite conclusion.
I think the single firm conduct working group certainly recommended the adoption of a single firm statute here in California.
Right.
And they did a lot of hard work on that, and I don't want to disparage that work at all. But it was not a study of whether there was a need in California for a single firm conduct law. It was a conclusion based on their life experiences, their work experiences, that they believed that a statute like that was necessary. And those opinions are important. They're well-meaning, I'm sure, but they're not evidence. They're not a demonstration of a need. It's the opinion of a handful of mostly economists that they thought it would be best to have California have its own single firm conduct law. I just haven't seen a study that indicates that we are here in California, we're suffering in some way because we don't have that type of statute.
Okay, thank you. Any other comments? Okay, hearing none. Thank you.
Thank you.
Anybody else? Okay, welcome back.
Thank you so much. Andrea Orden again, to speak on behalf of the present recommendations on the single firm project here.
Can you please state the organization? I didn't
And
catch
we
that.
are representing UFCW, Western States Council, It's a coordination of 11 local unions representing more than 200,000 representatives in grocery, pharmacy, food, and merchandise. You've heard from us before. We presented both in writing and in person starting in March of 2025, and recently have joined in the various coalition of labor union groups that have presented their both verbal and written comments. It has been an extraordinary journey that this commission has taken. Since Resolution 95, where the legislator said without dissent that they needed your assistance as the commission because of their concern about the lack of adequate and aggressive antitrust protection in California. And you have done that. You have done that with extraordinary experts, working groups who I believe truly have studied these issues. And you are now working out exactly where you want to be on the single firm question. And we would like to say that the work of the staff and the work of the commission's antitrust expert has been extraordinary. You've gone through thousands of pieces of paper. You've listened to not just the experts in antitrust, but people in public policy, economists, and workers, and people who have seen the impacts of the current antitrust climate. And we're here to say that we urge as strongly as we can the passage of single firm conduct legislation today. If we can turn now to some of the specific concerns that you've expressed and the draft language. Yes, we say revised option 2, the enhanced single firm conduct provision is what should be sent to the legislature for its continued work. And we would also urge strongly that the current language on restraint of trade does not need any additional adjectives. As it has been pointed out by the staff, CIPRO 1 and 2 clearly makes clear that restraint of trade does mean in California unreasonable. And if we start to add additional language, either in subsection C, or if we move it up to define the Cartwright Act, I'd share in the staff's concern that that has the potential of additional confusion, that somehow we're saying something different. So I would urge on our behalf that we do not add unreasonable. The one area in which I would urge on behalf of our clients that we still look one more time at that clear and convincing standard. It's just the intermediate standard. You know, it's not the highest standard. It's not a burden of beyond a reasonable doubt. And it is new and untested in antitrust. But in California, our lawyers, our judges are fully aware of clear and convincing and use it regularly. Your memorandum, the staff's memorandum, sets out very clearly the BADGE instructions that we're used to. So I don't think it's quite as untested as the staff worries. So we on behalf of our client, again, say strongly, think about why clear and convincing wouldn't be the best intermediate standard here. There's been this discussion on liberally and liberally construing. we urge also that we continue to do liberally construe. It's not really directed so much at the defendant's side of it. It's really a way that the legislature will say to the courts, to the judges, that this is a statute in protection of competition. It is to promote a public good. So if you look at sort of the history of those statutes in California, which include liberally, you will see that they are primarily those that have promote a public good. They are not the criminal statutes where you're protecting the rights of a defendant. So liberally is, I think, again, on behalf of the client, that is the right standard. Perhaps even the most important thing, not as the most important, but that as importantly, our group believes that the statements that have been drafted for first, the revised draft basic purpose statement, and then the revised statement reflecting California laws, preferences, and priorities as edited by the staff are excellent and crucial to this endeavor. And then also finally, adopting a statement clarifying specific elements of federal precedents that are not binding is equally crucial. It is a statement that needs to be made in order to promote all of the purposes that are in this statute. So we, again, applaud the way that it has been drafted and believe it is something that should be continued in this, either the uncodified statutory language or in the comments. Oh, and there is one other point. If you do look at, when you're looking at whether to include unreasonable, unreasonable is in some of the commentary language. So it is already in there in the current draft. So again, we urge that you do not put it in the statute itself. And with that, I close and thank you very much. If there are any questions. Thank you.
There we go. Thank you.
Sarah, can we ask folks who are on the line to raise their hands if they're going to want to do public comment? And it looks like we have 2 more people. How many more people in the room have comments? 3. So we're hoping if you can keep it to as close to 5 minutes as possible, it would be much appreciated. Thank you.
Welcome back.
Great, thank you. It's Dan Robbins, this time Motion Picture Association. I am the compliance officer for the company, so we represent the U.S. California film industry around the world. So part of my job is to keep these folks out of trouble, make sure they obey the antitrust laws. There's about 100 of them around the world. Earlier, somebody, I think from the American Economic Liberties Project spoke and made a really good point, which is you should always know who you're talking to and who's funding them. So the MPA has been around since 1922. We look out for people in California who make movies, who make television series, streaming, and it's a significant export industry for our country. That's who I'm speaking for right now. I think sometimes I've heard lots of groups with really fancy names. I just tried now to see who funds a lot of them, and it was hard for me. Even the American Economic Liberties Union, I was at their anti-monopoly summit earlier this week, and I couldn't tell you who pays the bills for the group. So you ought to ask folks when they come in front of you. I do really appreciate the work that staff has done and that Cheryl has done You've had a ton of stuff that was sent. I asked for a couple days extra and got mine in August 1, and there was like tons of stuff even this morning and late last week. So I sympathize with that. I do disagree with something that was said earlier, that there was no one in support of option 1. On May 22, I wrote a letter that partially was in support of option 1, which is to bring the Sherman Act into California law, and then at the same time, do what we did in the late 70s with indirect purchaser law, which is in, I think, like 16. What we did is we basically instructed California courts not to apply a decision from the U.S. Supreme Court that indirect purchasers were ineligible to sue for state antitrust violations. That's now in Cal Business and Professions Code 16750A. The way that process worked is we took a look at this case, decided it wasn't for us, had all the normal hearings about that issue, and made a decision on it, and the legislature accepted it. The governor signed it. It became law. We don't always reach this conclusion. So 20 years later, there was a desire to confront the Enron crisis, and one of Senator Dunn at the time, his idea was, well, it's this Copperwell decision from the U.S. Supreme Court in the antitrust world that's the source of our problems. So he fashioned a bill that didn't pass because the view of the legislature was, no, this Supreme Court case makes sense. And so what I urged in my letter is, if there's 9 cases like we apparently have that we think are terrible, we had to take the time and go through them like we did in 1979, like we did in 2000, make sure we're making the right decision, not just here's 9 that a bunch of commentators don't like, and we're just going to put them in here and disapprove of them. I think that's a shortcut. It concerns me. For example, one of them is this notion that we don't need to look at the relevant market. We don't need to look at where the harm is occurring. That's been the law for a long time. It's not a conservative idea. It comes from, Justice Earl Warren, the most liberal court we've ever had anywhere. And, he's got decisions where, he talks about this issue. In one, he says, look, without relevant market, there's no way to measure the defendant's ability to limit or destroy competition. We have to know where these companies are operating, what the market is, so we can properly assess the harm. We can't just throw that out. I think that's pretty important. I can tell you, in my practice, it's something we look at. When people come to me and say, hey, Dan, can I do this or not? This is something we look at. Like, okay, who are the people who are going to be affected here, in what market and how? I know it takes time. I agree with Cheryl. Sometimes I have to hire economists. I hired one to write an economic report for you all. I'm the only party who took that effort in this entire proceeding. But it's because it's important. These are things you need to understand. So in any event, I know it seems like you're past the option that I was pushing for, but I did want to make the point that somebody did push for it. And these are the reasons that I gave in the letter of May 22.
Could I ask you a question?
Oh, of course. And sorry if I'm going
interrupting,
fast.
but before you move on, I understand your concern about defining the market. And I know that, as you just said, you're in favor of option 1 and not option 2, but do you feel like the concept that you want to preserve of market definition, is that something that we could potentially add into option 2 in your view?
Well, I think it's better with it than without it. It's a very common tool. It's like a baseline tool, and Justice Warren wasn't saying anything crazy at the time. I think it came from the 40s as we gradually tried to figure all this out.
Well, so look at it through the other end of the telescope, which is assuming we don't do anything to affirmatively add it to option 2. Is there anything about option 2 that you feel like precludes a court from doing that? In other words,
Well-
by being silent on it, have we ruled that out in some way? Do you feel like we have to affirmatively say, please do this?
Well, I think when you look at all the language together, I think there's a suggestion that these, federal cases are somehow, all erroneous, and maybe some of them are and some of them aren't. I've also said before, we've had this law since 1890. That's a lot, 135 years of history. It's not all bad. Yet there were mistakes. I totally agree. But there's like a suggestion in here that it's not good. And I think the challenge, Commissioner, is that, as Cheryl suggested, doing this particular piece is hard. It takes time and effort. And, sometimes in the interests of judicial efficiency, if a judge can skip that, move to something else, they might. So, I do worry about that. I think it'd be better if it were, required, or at least that piece was removed. I'm sorry, any other questions? Yeah, the other couple other quick points. So globally, in these other 100 countries and in most of the other, if not all the other states, the idea is 1 for 2, 2 for 1. And what's that mean? Section 1 of the Sherman Act requires 2 or more parties. It's about conspiracies. It's about price fixing, market division, things that when 2 firms do it, they're guaranteed to reduce competition. Because instead of competing with each other over price, or where am I going to sell and where are you going to sell, instead of agreeing on that, they sell in the same place and try to provide consumers with the best value. It's always 2. And then in section 2, it's 2 for 1, which is one entity, like Mr. Ensign said, monopolization, mono, means 1. And so my biggest concern with what you're doing here is you're creating a hybrid. You're creating something. This is not how it's done in the European Union. It's not how it's done in the People's Republic of China. It's not how it's done in Indonesia. I could go on and on. We'll be unique, but if we fall on our faces, that's not going to be good. And I think by combining these 2 things together, it's a mistake. It's a mistake. I think what we want is, firms to be prohibited from doing all these things when they're acting jointly. Price fixing, all these other things, completely illegal. 100% agree. But you can't apply the same rules to a single firm. So if I'm a single firm, especially since you're looking at all different levels, from little firms to big firms. We've rejected the market power, misuse of market power. It's sort of, individual firms pick their prices so they can be competitive. They decide what markets they're going to participate in to be competitive. They may bundle some things up. Have you ever been to a buffet? That's bundling. It's all together. It's $20 for as much as you can eat. So I think those things need to be split. Frankly, I think that's probably the biggest problem with this proposal. And again, it's, maybe we can do better than a lot of these other countries, but being different, just to be different, the fact that, the other 99 do it one way and we currently do it that way too, there's probably some wisdom in that. Just 2 other quick things, and I appreciate your patience. I don't think we should go with this clear and convincing evidence standard. That it's the general standard is preponderance, and just as an example, clear and convincing is used only in certain situations. So, for example, if you're going to challenge the validity of a patent that was issued by the United States government, the idea is, well, the government ought to be given some deference. There's patent examiners there. They work on it for years. We had to give these people the benefit of the doubt for sure. And so if I'm going to challenge the validity of a patent, I got to prove that by clear and convincing evidence. It's a higher standard, but there's a reason for that. I think here injecting that into pro-competitive effects and things like that, I think that's a mistake. And then finally, this notion of a presumption of over-enforcement, let's not forget, this is a criminal law. And I don't think it's the state's policy to over-enforce criminal laws. So, we just finished amplifying some of the penalties in one of the, I think maybe the only antitrust bill that passed this last session. So just be mindful of that. It's not only a civil exercise, it's a criminal exercise. And anyhow, so those are the thoughts I wanted to share with you, and I appreciate your patience. And again, I think the staff's done a great job. They've had rained on tons of submissions. I'm coming quite late, and they've done a good job of pulling all that together. So I don't mean to criticize that at all. And when I bring these suggestions to you, I know my union friends are only complimentary of you, and I challenge you. So but it's part of the process. That's how you get better. So thank you very much.
Great, thank you. Any questions or comments for Mr. Robbins? Yeah, David?
One kind of conceptual question for you, Dan. So I get that one of your points is that we're taking a set of activities in 16.720 that has always been acts in furtherance of a conspiracy, essentially. If you take it out of that context, if you take it out of any context and just read the list of acts in that statute, it strikes me that they are acts that can be achieved by a single person acting alone.
Right.
So I don't, a lot more about this than I do. I don't disagree with your characterization that it has always been thus. I concede that that's true. And I also concede that making these acts, subjecting them to liability when they're accomplished by a single person, like that would be a new thing. But why is that necessarily somehow contradictory conceptually? Because there's no reason that these things can't be achieved by a single actor. And especially if one of the aims here is to impose liability on competition impairing acts by a single big actor potentially. That's how you do this. You make all these acts that heretofore have always required more than one person. From now on, one person can do them. And the kind of person that can do that is a large market dominant person. So without having to define market dominance or abusive dominance, we, in your phrase, we criminalize these acts when they're done by one person. And it'll, as a practical matter, only apply to a certain segment of market actors.
But we don't have a market share requirement in there. Because you're right, today, under federal law, and may not be perfect for sure, most cases you have to be fairly large, 75% of the market, and then all these things you can do, can get you severe liability. But the reason for that is when you do these things and you're really big, you can really hurt somebody. When you do these things and you're the only hardware store in town, is it really going to have the same impact? That's
not on your competitors necessarily, but it could have market effects, anti-competitive effects, such as precluding other competitors, potential competitors from coming in, and more likely it's going to have effects on consumers, adverse effects. So it's one of the common knocks on Amazon is that by underpricing independent booksellers, they drove them all out of business. And now there's basically only one place to buy books, which is Amazon. They've created their own monopoly. Now they can charge whatever they want for books. That's sort of how a monopoly works, right? When Amazon was competing in order to get to that place that it's at now of, let's call it market dominance without sticking a number on it, they may have engaged in some of these activities. And in that growth stage, acting by themselves, strictly speaking, these, like existing law would not have captured that. And even with this single firm conduct, it still might not capture it, but it will capture it going forward once once they've achieved that goal, and there's essentially no one for them to conspire with, but they're still acting anti-competitively. So I think that at some point there's a practical threshold that gets crossed over. And by making these acts subject to liability for single firms, we capture that market dominance effect without having to set an arbitrary number on it. If you're worth more than $500 billion, but less, it doesn't matter. And I'm just wondering, like, why is that conceptually the wrong way to go?
It's, yeah, I'm trying to think through that example, and I'm pausing because you might recall there was also a conspiracy among the booksellers with Apple that was the main target of the prosecution and which was successful. So that's what's that's the first thing that I went to. But I think having it just taking all the Section 1 conduct and importing it in is we have there's always been more concern about Section 1 violations because it's pretty clear that they harm people. The Section 2 has always been a lot more ambiguous because a lot of these things, can be mistaken for severe competition. This is why, the Brook Group case gets so much attention. We want people to compete by charging lower prices generally, but how low is too low? I struggle a little bit with the Amazon case. I apologize because I keep, I'm aware of the conspiracy.
Other large company.
which was prosecuted, successfully against the booksellers and Apple, I believe.
Okay. Thank you.
Yeah. Great. Thank you all.
Oh, Maria?
Can I ask Cheryl a question?
Sure.
I thought I saw in the single firm conduct report that there were other states that have laws that impose liability for single firm conduct. Is that right?
Yes, in fact, almost all of the states, as well as the federal government, have antitrust laws that reach both single firm and multi-party conduct. We had some unfortunate California Supreme Court rulings that looked at our Cartwright Act and said, well, we don't think it but other states have very similar laws and the courts haven't restricted it that way. So we in New York are actually two of the outlier states that don't.
May I just address that briefly? Cheryl's right about that. There are other states that have single firm conduct provisions. I think all of them are akin to Section 2 of the Sherman Act, which outlaw monopolization, right? Not a single one of them says that a single firm may be liable for a unreasonable restraint of trade. That has always been reserved, and to this day, in every antitrust jurisdiction I know, for conduct among multiple firms. So the single firm conduct state laws that do exist are mostly patterned, if not all patterned, after Section 2 of the Sherman Act, which prohibits monopolization and only monopolization.
Actually, a lot of them take a different form and are more like a Section 5 of the FTC Act and are very broadly ban unfair and
Sure, which we certainly have in California. We have the unfair competition law, so Section 17200. We have that type of law here in California.
Okay, thank you.
Thank you.
Next. Welcome.
Hello, good afternoon, everyone. My name is Tasia Kiefer, and I am an advocacy manager here on behalf of the Los Angeles County Business Federation, also known as BizFed LA. We advocate on behalf of 420,000 employers and 5 million employees across Southern California and throughout the entire state as a whole. I really appreciate, and our organization really appreciates the immense amount of work that's gone into this issue. And we also really appreciate how seriously you guys are taking the public comments. I do want to just highlight that we did submit a joint coalition letter of 16 business groups here in California in July for your consideration that have more details. But today, my comments will be brief and to the point of the single firm conduct and the antitrust laws that are being proposed to today. So I'll just start with our 3 general member concerns. So 1, the proposal does seek punishing size and not necessarily harmful conduct. The draft creates a double standard. The same business practice could be considered illegal if done by a large company, but permissible if done by a smaller competitor. Antitrust law should focus on actual consumer harm and not the size of the company performing the activity. And 2, proposal threatens everyday business practices. So bundling, loyalty programs, and volume discount benefits. These are things that benefit consumers through lower prices and having more choice, and treating these practices as presumptively illegal for larger firms would discourage companies from offering these affordable services. And 3, this proposal increases the likelihood of litigation risk and costs for businesses. The proposed burden shifting framework would force companies to prove the legality of routine business conduct. Antitrust cases are already expensive and time consuming. That was mentioned already earlier today in this meeting. And that being said, this approach would create additional unnecessary legal risk and divert resources from the growth here in California. And I'll end my comment with this. So every year for the last 16 years, the BizFed LA, we conduct an annual poll to get a pulse of the business community here in California and where they stand on different policy areas. And in 16 years, this was the first year that we had an enormous over 50% of our poll takers indicated a high level of uncertainty in conducting business, especially when it comes to economically speaking. And so that being said, in the face of immense economic uncertainty in the business community, we urge the Commission to carefully reconsider these proposals and refrain from adopting changes that would undermine the precedents of competition that already exist. And we do believe that maintaining a clear focus on actual consumer harm and preserving the established evidence-based framework of antitrust law is crucial for promoting economic growth and ensuring a vibrant and competitive marketplace here in California. Thank you.
Thank you. Are there questions or comments from commissioners?
Thank you.
None? Thank you so much.
Thanks for your patience. Ben O'Brien here again on behalf of California Life Sciences. Again, we represent over 1,300 organizations across the state that are all engaged in the state's life sciences ecosystem. So those range from academic research institutions, biotech, pharma startups, all across the board. So again, advocating on behalf of those members and the important economic drivers that they produce for the state, as well as for the treatments that they produce for patients. So again, just jumping into the specific single firm conduct, I rise to express some concerns that we still have with the options outlined in Memo 2541. While we share the Commission's commitment to protecting competition, we believe the proposed provisions would create significant uncertainty, potentially chill pro-competitive activity, and ultimately hinder innovation in the life sciences sector that is essential to both public health and California's economic leadership. So just jumping to those, I'd just like to highlight a couple of our specific concerns that may have not been touched on so far. So first, going into the proposed purpose statements and statements reflecting California's laws, preferences, and priorities, we feel we have a couple of trouble spots with certain kind of ways that they're drafted currently. So particularly, we have some trouble with their explicit rejection of certain federal precedent and traditional standards for evaluating competitive conduct. We feel that those kind of rejections will again create significant legal uncertainty for our members. Of particular concern is the suggestion that certain cases under Sherman Act 2 could proceed without defining or proving a relevant market, as well as framing of antitrust enforcement in relation to labor. This approach departs from the consumer welfare standard that has served as the foundation of U.S. antitrust law since the 1970s. We're further concerned that instructing courts to liberally interpret California antitrust laws to maximize enforcement invites overly broad interpretations that would expose our companies to unpredictable risk. While we do recognize it is written in case law, I guess my comment to that would be, we don't want to import just everything from one decision and then make that codified kind of more broadly. Then jumping into option 2, under revised option 2, we remain concerned that adopting new restraints of trade violations for single firms could deter collaborations within the life sciences ecosystem. So this kind of goes back to some points I was mentioning earlier, where our ecosystem really depends on a lot of dynamic movement, a lot of mergers and acquisitions, and a lot of involvement of larger companies partnering with smaller entities to advance their scientific innovation to market. So we feel that the novel single firm provision outlined in option 2 could capture many of these pro-competitive patent and licensing agreements under the umbrella of restraints of trade. Ultimately, that risks the slowing of innovation and again could drive emerging firms to other states where environments are more friendly. Again, we are concerned kind of with option 2, as it would give state courts this power where they've never ruled on what constitutes a restraint of trade in a single firm context. And this could introduce significant uncertainty for regulators and businesses. Lastly, I'd just like to say, as many folks have said, we really appreciate the staff's work on this issue and the commission's willingness to solicit input and feedback and genuinely engage with that feedback. We continue to believe that California's specific single firm conduct provision is not necessary at this time, but should the commission move forward with one of the proposed options, we would respectfully request the opportunity to review and provide comment on a final version of that language before a vote. Again, thanks for your consideration. Those are our comments at this time, but happy to take questions.
Thank you. Are there questions or comments for Senator? Thank you. Okay.
I think we're ready to move on to
Online.
our online folks. And just as a reminder, it's 3:05 already. And so if you could keep your comments as brief as possible, so the commission has time to return to the memo and take appropriate action, we would very much appreciate it. And please state your name and organization for the record.
Okay, so we have Lee Hepner.
Oh, okay.
Good afternoon, commissioners. My name is Lee Hepner. I'm an antitrust attorney with the American Economic Liberties Project, a nonprofit advocacy organization. I'll take the cue from my friend at the Motion Picture Association and offer that we get funding from various nonprofit foundations, which are all public record, no money whatsoever from private corporations. We have been engaged in this commission process for nearly 3 years since we first submitted a letter in January 2023. And again, my thanks to staff and this commission for their extraordinary work to this measured, to arrive at this measured, reasonable list of recommendations. I also want to thank Senator Blakespear for her comment that the legislature is waiting, and I do hope that this commission can act today. You are seeing an interesting preview of what this legislative process is going to look like, and you see some of the politics in the room. I'm certain I'd find room for agreement with Mr. Robbins at the Motion Picture Association. Despite some disagreements here today, I'm thrilled to hear he was at our annual summit this week, as were dozens of business leaders, labor leaders, and policymakers across the political spectrum. I have some criticisms of some of the other entities and sort of motivations in the room, but I'll politely stop there. This antitrust reform effort does not exist in a vacuum. Markets today are dramatically more concentrated than they were a quarter century ago, and consumers, workers, and innovative small businesses are being shut out of markets, confronted with skyrocketing prices, and deprived of opportunities to practice their trades. From price fixing to illegal monopolization, the overwhelming errors that we are observing in the courts with antitrust administration have been false negatives, where judicial loopholes have eroded the application of laws designed to preserve fair, open, and innovative markets. In that context, I believe the charge before this commission is to recommend a single firm conduct standard that dispenses of harmful judicial interpretations of federal antitrust law that have rendered the law unpredictable and extraordinarily expensive to enforce, such that only the most well-resourced public or private parties can afford their day in court. That's what option 2 and the findings and declarations seek to do. A few finer points very quickly. First, of course, we support the findings and declarations. I believe the commission can adopt these with little controversy. These findings and declarations reflect the best interpretations of California law dating back to the Cartwright Act's codification over a century ago. I'm a little concerned by the suggestion that this commission would reject one of those findings contra an interpretation of the law by the California Supreme Court. I do hope it finds that adopting the findings and declarations in full is the right way to go. Second, unreasonable. The word unreasonable is not a necessary insertion here. It doesn't exist elsewhere in federal or state antitrust black letter law. In fact, inserting the word unreasonable may risk communicating to courts that the legislature is revoking a century of law that says certain forms of conduct are unreasonable on their face or per se illegal without any consideration of reasonableness. So unreasonable is both unnecessary. It is also implicit in the commission's comments, as other commenters have noted. And I would caution risk taking a big step back from the status quo treatment of per se illegal offenses. Somebody else recommended inserting a market definition exercise into option 2. That has the same effect. The advent of per se illegality is that it confronts conduct that is so harmful that it is in itself illegal without any expensive market definition exercise. Third, the project of creating a law that minimizes discretion and that is less costly to enforce benefits from a clear and convincing standard, which I'll add implicitly acknowledges that reasonableness standard that the commission is discussing. Courts are currently being asked to traffic in hypothetical representations of how future markets will behave, how competition might emerge, informed by highly speculative and extremely expensive reports by hired economists. Trafficking in loose hypothetical undermines the force of law. I think Ms. Johnson, I don't want to mischaracterize her remarks because her microphone was cutting out a little bit, but also articulated that the rule of reason in many contexts is why antitrust cases are so difficult and expensive to bring. And I would heartily agree with that. If this commission is seeking to recommend reform, a clear and convincing evidence standard for a defense to the general prohibition is important. And contrary to assigning that standard to a plaintiff's affirmative burden, I do not think it is a drastic departure from a preponderance of the evidence standard. Fourth and finally, and perhaps most critically, harm to competition in one market should not be offset by benefits in other markets. There was a little discussion about whether to codify a ban on the consideration of out-of-market pro-competitive benefits. Commission staff has represented that that is unnecessary. And because it is an articulation of existing law, although Ms. Johnson, again, I think said today that courts often ignore that. And we just saw that happen in the Google search case. The Google search case is extremely interesting because the court in that case abandoned its obligation to terminate Google's monopoly in the markets for search and search advertising because of ostensible benefits in markets well outside that relevant market. Benefits to Apple in the iPhone market, or Samsung and Motorola in the Android market, or benefits to browsers, or benefits to wireless carriers. And so despite having been declared an illegal monopolist in 6 separate antitrust markets by 3 federal courts, you see the erosion erosion of antitrust law's ability to terminate the monopoly through the consideration of these out-of-market pro-competitive benefits. It is a very dangerous camel's nose under the tent. I do believe that opinion is going to be appealed to the Supreme Court, and this commission would be on the right side of history in codifying the prohibition on out-of-market pro-competitive benefits up front. I am aware that Google submitted a letter this morning. I just hope that we all recognize that for what it is. It is a preview of the extensive and very expensive lobbying efforts that Google and their agents will engage in next year to erode even an incremental improvement to California law. This is going
Mr.
to be
Hepner, can you wind up here?
Yes, this is going to be a long and arduous legislative process, and the commission is on sound footing adopting option 2 and the findings and declarations today. Thank you.
Great, thank you. Any questions or comments from members? Hearing none, our next speaker.
And please remember to keep things brief. Time is moving along, and I believe the commission would really like to address single firm conduct at this meeting. Thank you.
Yeah, and we have about 8 or 9 more speakers waiting. So we want to give everybody that we can a chance to speak, but try to be brief.
All right, we have Amy Hines Shake.
Hello, Honorable Chair Kurian and Commissioners. My name is Amy Hines Shaik with UDW AFSCME Local 3930. We represent over 220,000 caregivers across California. Many of them are low-income workers who are the most impacted by uncompetitive behavior. We have submitted our written public comments, and I will provide a brief overview of them. We commend the staff on their continued excellent work regarding this ongoing study on a single firm conduct. We endorse option 2 with critical improvements, including simplifying the general prohibition against restraints of trade, establishing clear standards of proof, and creating per se violations for conduct by firms with substantial market power. We also strongly support the enhanced purpose statement and the rejection of weak federal precedents. These provisions will provide courts with clear guidance, ensure fairness and consistency, and ensure that California's antitrust law stands on its own. We urge the Commission to take immediate action at this meeting to vote on and approve these recommendations regarding single firm conduct. At this point, delaying action could only allow harmful consolidation to continue. And with that, I'm going to take your word for it that you might actually want to take action right now and stop talking. Thank you so very much for hearing our comments.
Thank you. Thank you very much. I appreciate it. And any comments for the? Okay, thank you. Next.
We have Jen Suh.
Okay.
Hi, my name is Jennifer Suh, and I'm speaking on behalf of the Writers Guild of America West, a Los Angeles-based labor union that represents more than 10,000 professional workers in media and entertainment. I want to thank the Commission and CLRC staff for your immense work on this antitrust study to modernize competition law in our state. And I appreciate Senator Blake Spear's position on moving the Commission's recommendation on single firm conduct forward as we discuss other antitrust topics in the future. The Commission has engaged in meaningful work reviewing potential revisions to California antitrust law, focusing on a well-known shortcoming in our state, the exclusion of single firm conduct rule. Since this antitrust study began nearly 3 years ago, the Commission convened an expert working group to study single firm conduct. That working group released a comprehensive report more than 18 months ago, and CLRC staff have drafted single firm conduct language proposals with the most recent draft released this past June. The public has been given ample opportunity to comment and engage in this process. And for these reasons, the Guild recommends no further delay and urges the Commission to take immediate action at today's meeting on staff single firm conduct provisions. Specifically, we urge the Commission to vote on and approve option 2 in conjunction with the enhanced purpose statement, the statement rejecting federal principles, and the statement rejecting federal precedents. The codification of the 3 statements clarifies that this change to California antitrust law will operate independently of federal precedents and that protecting competition in labor markets is an essential component of antitrust law. We urge the Commission to take advantage of this timely opportunity to jumpstart much-needed reform in our state by adopting option 2 and the 3 statements proposed in staff's single firm conduct report without further delay. Thank you.
Thank you very much. Next speaker.
Bryn O'Neill.
Hello again. Thank you. I'm Bryn O'Neill with the California Nurses Association, a labor union representing over 100,000 registered nurses across California. We've submitted several coalition letters already, so I'm going to second Lee Hepner's comments on the details and keep this real high level. We strongly urge the Commission to adopt Option 2 on single firm conduct at today's meeting. Option 2 and the 3 proposed statements are ripe for a vote today. Public commenters have weighed in on the draft for months, and California legislators are in the process of determining their legislative agenda for next year. They need a signal from the Commission about the direction of their recommendations now. Legislators can and will tweak language as needed as it goes through the legislative process. After voting to adopt single firm conduct today, the Commission can and should continue to work on additional recommendations in the other categories. Please do not be deterred by comments from industry groups objecting to anything new and defending weak federal precedent. They're not trying to take the time to get this right. They are trying to avoid all regulation. The entire point of this exercise, of years of work by you and the staff that was called for by the legislature, is to reform and improve antitrust law. Current California and federal antitrust law is not getting the job done. Market consolidation in healthcare is at a crisis level. Single firms engage in anti-competitive conduct, and nurses, other healthcare workers, and our patients end up paying the price. We urge you to act now, today, so California does not have to wait another year to begin to turn the tide on this behavior. Thank you so much.
Thank you. Any questions or comments from Ms. O'Neill? Thank you. Next presenter.
Samantha Gordon.
Okay.
Hello, good afternoon. My name is Samantha Gordon. I'm with Tech Equity. We're a nonprofit focused on ensuring the growth of the tech industry is beneficial for everyone. I will just echo Lee Hepner's comments as the previous commenter did. We've submitted many coalition letters as well, and I will be brief, but thank you for the excellent work conducted by the Commission and its staff in providing really thoughtful and, frankly, careful analysis on how we can ensure competition that fosters innovation and strengthens opportunities for workers and consumers. And, as I stated, we've worked in close partnership with many of the organizations speaking here today and would generally echo their comments. Specifically, we want to urge the Commission to adopt Option 2 within the single firm conduct recommendations. And we echo, calls from our partners to make some of those critical improvements, including simplifying the general prohibition against restraints of trade, establishing clear standards of proof, and so on. We also strongly support the enhanced purpose statement and the rejection of weak federal precedents. Most importantly, we urge the Commission to move forward and vote on the single firm conduct recommendations. We have watched you all go through a very lengthy and thoughtful process to ensure voices from key stakeholders were considered, issuing numerous reports, adjusting findings. And we would really think about, how does a delay serve the people of California? Does it serve the small businesses who are hoping to be competitive in a market where resources are further concentrated into fewer and fewer hands? Does it serve the workers who want more options and opportunities to find competitive wages? Or would it serve large companies who want to ensure that they can continue to engage in the status quo on antitrust matters? We've already seen the results of that, driving up prices on groceries, restricting access to healthcare, all while suppressing wages. So we thank you for your time.
Thank you so much. Any questions or comments from Ms. Gordon? Okay, thank you. Next speaker.
Robert Harrell.
Good afternoon, Commissioners. I'm Robert Harrell. I'm the Executive Director of the Consumer Federation of California. I'd like to thank the work of the commissioners and your staff. I'd also like to particularly thank the comments of Commissioner Carrillo over the course of this meeting. I think they're very helpful and focused, and we appreciate that. I'll be brief. We support Option 2 with some of the enhancements. Don't know that you need unreasonable for the reasons previously stated. I would just note a couple of things. One, another industry where you've seen single firm conduct that has been very damaging to consumers and what little competition there is, if any, is the live entertainment and ticketing industry. And that's a great example where monopoly and monopoly behavior stifles innovation and harms consumers and marketplaces. And I think that's the general rule for what you ought to be thinking about as you contemplate a single firm conduct standard. I think you must act today. Appreciate the comments of Senator Blakespear. This is, and I don't mean this disrespectfully, this is approving something that will then go to the starting line in the California legislature. I think you've spent lots of time working on this issue in great detail, fantastic and excellent research and work, and it is time on single firm conduct to move and vote. I will just close with, I don't think the standard ought to be when the chamber tells you what is a passable bill. That is not the role of the CLRC. The role of the CLRC, as you've been taking very, very seriously, is to come up with the best policy options and figure out what you think is appropriate to move forward. It is then the job of the legislature and the governor to decide how and in what ways the law may be changed. And I say that with a great deal of respect to all the members of the commission and the work that you've put in. With that, I thank you very much for the time you've spent on this. Urge you to support a modified version of option 2, and thank you for your listening. Appreciate it.
Thank you. Any questions or comments for Mr. Harrell? Okay, next speaker.
Peter Leroy Munoz.
Yes, good afternoon. This is Peter Leroy Munoz of the Bay Area Council, an organization advocating for California's business competitiveness and innovation economy. We join other trade associations, chambers of commerce, and businesses of all sizes throughout California in sharing our concerns with proposed changes to the state antitrust law regarding single firm conduct. Now, a previous speaker from LA County BizFed, she and I have been a partner on a variety of different collaborative letters, and I think those articulate in detail many of the concerns that we have. But I did want to add just a little bit more to that. The state's historical antitrust focus has rightfully remained centered on consumer protection, and a shift in antitrust law from consumer protection to market competition risks confusion, doctrinal conflict, and under-enforcement of traditional protections, including discrimination, price gouging, and unfair contract terms, among others. Presently, many of the largest technology companies in our state provide consumers with interconnected, customizable digital tools at low or no cost. This is proof that existing laws protecting consumers work. California should fortify these consumer protections, not dilute them. Thank you.
Thank you. Any questions or comments for Peter? Okay, thank you. Next speaker.
Devon Gray.
Okay.
Hi, everyone. My name is Devin Gray. I'm the president of End Poverty in California. I'll be super brief here as well. I just want to echo the sentiments of those who have called for the commission to advance the second option on single firm conduct, excuse me. Many people today, and obviously over the last many months, have already explained and litigated the merits of this, but the perspective I'd like to add is what Californians in all corners of the state are experiencing. So our organization spends considerable time in communities up and down the state, and regardless of geography, regardless of region, there is really an overwhelming and I would say justified perception that is against people. And it's not really hard to see why. It is now harder to build wealth. The cost of living is pricing people out of the state. And California has the highest poverty rate of any state, now tied with Louisiana. And in diagnosing the causes of these problems, ordinary people really do identify the immense power held by the largest firms who engage in activity that is often both anti-competitive and anti-democratic. People really do see it. And I think to ameliorate this, we really all are being collectively called to act. Californians want our state to be an example for the rest of the country in how we can unrig the economy through both helping small businesses compete and ensuring workers can thrive here. But I think the longer that we wait, the harder it will be to turn the tide in an economy that continues to work against average Californians. And our failure to act on this and many other issues will certainly continue to see Californians leave the state or become trapped in economic stagnation, neither of which, of course, are healthy for our state or even our national democratic project. So I think we have a choice here. We either make California work for people, or we allow for the national momentum of corporate consolidation to go unchallenged as it continues to harm working class Americans. Thank you, and really appreciate all the work that people have done on this.
Okay, thank you. Any questions or comments for him? None? Okay. Next speaker, please.
Bianca Bloomquist.
Okay.
Hi there. Good evening, commissioners. Thank you for the opportunity to comment. And thank you for your ongoing commitment to making sure that California's antitrust laws are strong and support small business owners. The Small Business Majority has submitted several coalition comment letters, but I have several comments from very small business owners from Modesto, Granite Bay, and Redwood Valley who took the time to speak with me. And they've asked me to share their experiences with you. So in the interest of time, I will only read one of these comments. And if I may submit these small business owner comments for the record, I'd certainly appreciate it.
Sure.
Thank you.
More than welcome.
I appreciate that. My name is Bianca Blomquist. I'm the California Director for Small Business Majority. We're a national research, advocacy, and education organization. We represent 85,000 authentic small business owners. A third of our small business owners are business owners of color. 1/3 are women, and the average size of a business in our network has 4 employees. These very small businesses are the largest subset of small businesses. They're our state's most prolific job creators, and these are the businesses that are most harmed by unfair competition. We've been following the commission's work closely. The draft language on single firm conduct has been before the commission for months, and over the past 6 months, many commenters, including Small Business Majority, have supported option 2, the findings in the enhanced purpose statement. Our research, in fact, shows a growing uneven playing field between small and large companies. Therefore, it's very important the commission moves forward today, approve what is ripe, and then continue its work on misuse of power mergers separately. 56% of small business owners say one or more large companies dominate their industry. 56% also agree that large companies have an unfair advantage. 44% say monopolistic practices have increased in recent years. 83% believe large companies have the resources to take small businesses' creative ideas. And 82% agree our economy is changing for the worse. It's time to update our laws here in California. So the business experience that I will read comes from Savannah Williams. She operates a small business in Modesto. She says, as a one-person digital media business, I've seen firsthand how the system is rigged against the little guy. My income is razor thin, and the biggest obstacle isn't the work itself. It's the constant, overwhelming cost of simply trying to compete. Every little fee for marketing, software, and online marketplaces that I'm forced to use eats away at what I earn, making it impossible to grow. The biggest challenge is not about the quality of my work, it's about the unfair advantages that large corporations received. I am forced to use the same platforms as multi-million-dollar corporations and run by multi-billion-dollar corporations, but I'm hit with the same fees and rules without any of the benefits larger competitors get from volume and scale. This means my business is directly competing against companies that pay less for the same services and supplies that I need to survive. For me, the risk is real. My innovative ideas and the unique services I offer are at risk of being copied and sold for cheaper by the same large corporations that own the online marketplace I'm forced to use, that can then afford to take a loss on a product for as long as it takes to put me out of business. Policymakers need to understand that fair competition is not an abstract idea. It's about survival for small business owners like mine. When the deck is stacked against us, innovation and consumer choice suffer. The entire economy becomes less dynamic. It hurts our workers, and we become less resilient. That is the end of her story. So again, I urge you to adopt a modified version of option 2, and thank you all very much for your time.
Thank you very much. Are there any questions or comments for Ms. Bloomquist? No, okay. And is there one more?
There's one more,
Okay.
Terry Oli.
Okay.
Good afternoon, commissioners. This is Terry Oli. I'm the Director of Economic Security California Action. We are an issues advocacy organization focused on building an economy where everyone has the freedom and stability to thrive. And I do want to just refer you to our letter that's already been, several letters actually, comments that have been submitted on this topic. I want to kind of just broaden the aperture again and talk about the what is at hand today, and really implore you, urge you respectfully to move this piece forward and vote today to advance a version of the single firm conduct language so that there's actually time for the legislature to take this up in the 2026 leg session. For those of you who are familiar with how the legislative session works, I think you know that there will be, this is phase one, what you're doing, which has been incredible. But there is a long and arduous and robust process in the future, expecting a minimum of probably 3 subject matter committee hearings, probably an additional 2 fiscal committee hearings, and of course, floor votes in 2 houses. And in fact, actually, I hope that given the expertise that this commission has developed over the last couple of years, that you will actually engage in that process and make yourselves available to the legislators and committee staff who will be taking this issue up and parsing through every single word that has already been spoken or written. I think I'd like to address for just a minute the opponents of taking action. I just, you know, although there was a lot of detail provided today about, you know, the specifics, I think that the general sentiment of the opposition can be summarized this way: not here, not now, and not like this. And so whether the opponents have, you know, opposed this by kind of bucking the hypothetical, the idea that there's not conduct being, you know, that single firms are not engaging in conduct that is undermining competition in California, the idea that there's not corporate consolidation in California, or that if there is, it certainly isn't harming consumers by raising prices or reducing choices. That's sort of the, you know, the table stakes in order to, that's like the flavor of the day to advocate for not taking any action or to go back to the drawing board and do more research. I am relieved to hear that the commission does not seem inclined to agree with that point of view. However, allowing more delay, continuing to kick the can down the road on this topic, which has received so much input already, is in order to say, like, craft the perfect bill that, you know, may be passable or not, which again is, I would agree with Robert Harrell, not the purview of this commission. It basically has the same effect. It undermines the impact of the overwhelming evidence that has been put in front of the commission in support of updating Cartwright to reach single firm conduct, so that conduct by California firms can be held accountable for anti-competitive behavior under California law. And just, you know, one more point, which is, you know, and while the work of the commission is rooted in policy, I think it would be a mistake to ignore the bigger reason we're here that my colleague Devin Gray touched on. There is a very real affordability crisis in the state of California right now that threatens the current state of our economic stability, and really threatens the future of the kind of preeminence of the Golden State. And a key component of that is the broken markets that no one can budget their way out of. Consumers face higher prices, fewer choices, small businesses iced out of communities by dominant players. And and really all of this just undermines the central tenet of capitalism, which is robust competition in markets. So with that, I would like to just reiterate my comments that have been submitted in print to urge you to please vote today to advance option 2 with the critical improvements that are, you know, have been detailed at length, and move this forward so that we can really recognize the great work that you have all done over the last couple of years, and move to the next phase of addressing this hole in our current statutory framework so that we can solve the problems that so many Californians are facing. Thank you.
Okay, thank you. Any comments or questions for her? Thank you so much. And that's the end of the, okay, public comment. All right. Okay. So now it's time to go back and walk through the
Yes.
decision points.
Yes.
Correct?
That is correct.
All right.
So the first decision point is, does the commission want to, I'll find my magic words. Does the commission want to direct staff to treat single firm conduct as a sequenced report? So that would be the first in potential series of reports to the legislature.
Right, this would be an explicit action that would go separate from the.
That's correct.
Okay.
It would be the first recommendation.
Okay.
That would go in a report to the legislature. I do think that a motion is required because the commission had previously made a decision to
Right.
keep things consolidated.
Okay, is there a motion to?
I'll make
move
a motion
forward?
to that effect.
Okay, and there's a second.
Second.
There is a second, motion and a second, it's been moved and seconded. Can you call the roll?
I will. Commissioner B?
Aye.
Senator Blakespear?
Aye.
Commissioner Carrillo?
Aye.
Commissioner Hebner?
Aye.
Commissioner Jenkins had to step away. Commissioner King
Aye.
and Commissioner Simpson.
Aye.
Okay.
Now we're moving forward on single firm.
Yeah, so now we are going to the first,
Page
sorry,
8.
I'm a little off here. So the first question before the commission is whether you want us to keep working on option 1 or with or without revisions, or would you like to direct staff to no longer work on it?
I suggest nay on option 1.
I second that.
It's been seconded and thirded. Okay,
So
Oh.
this to restate for the record, this motion would tell the staff to discontinue work on option 1.
correct.
Okay, Commissioner B?
Aye.
Senator Blakespear?
Aye.
Commissioner Carrillo?
Aye.
Commissioner Hebner?
Aye.
Commissioner King?
Aye.
Commissioner Simpson?
Aye.
Okay, so now we're going to move to revised option 2. This one's a little harder because there were various suggestions,
Mhm.
but let's just go through and make sure we're on the same page. There was some language on page 9 relating to unreasonable restraints of trade. I think we have heard some comments urging the commission not to insert the word unreasonable in statute with concerns that could cause questions about whether that would create a new standard. On the other hand, I think we had commissioners stating that if the term unreasonable is inserted, it should be inserted, I believe, in subdivision A.
Probably A and B.
A and B.
Maybe a question for Cheryl. Refresh my memory on the distinction. Unreasonable presumably is a little stricter standard for what is or is not a restraint of trade.
Cheryl, I think your mic's off again.
It's off again. Okay, sorry about that.
Yeah.
Unreasonable is the interpretation that the courts have used to limit or qualify what restraints of trade are unlawful under both the Sherman Act and the Cartwright Act.
And these
So,
are,
and it is not, we do not, even though we use restraint of trade under the Cartwright Act, we don't put unreasonable in front of it.
But it's
people
understood to mean
understood
that.
It would be interpreted as unreasonable restraints of trade.
So would we be safe, as the staff suggests, clarifying in a comment that we're not intending to break any new ground?
I would think so. I think if you put it in the statute, one place in the Cartwright, and it's best, and you have restraint of trade that isn't qualified, then it might suggest that there's a new standard.
Yeah, that's why if we're going to do that, I think we have to clarify on the comment that it's inferred from existing law. And
Yeah,
Go
I'd
ahead.
like to just also
Senator?
amplify that. So the public commenter who recognize that the definition, when it's basically per se prohibited, so adding unreasonable might actually be weakening it. So I do, if we want to add that in, I do think it's a good idea to put in a comment what our intent is.
That would be my suggestion.
Maria?
Or not put unreasonable in the text and then if we.
Correct.
Right, I think that would be cleaner because it already has
Yeah.
a definition in law.
That's
Yeah.
correct.
Okay,
Correct.
I'd be okay with that.
So comment, but no change in the text.
So it would, the language would read as it does on page 8. And then rather than a subdivision C of the same section, we would put that, or we put something in a comment?
We
Yeah.
put it in a comment. We'll have to do comments anyway. And I think that just having restraint of trade in there right now, that would prompt staff to write a comment for the commission's approval. This is, the idea here is to adopt the commonly recognized judicial interpretation of restraint of trade, or however it's appropriately drafted.
Yeah, I'm looking at the text that goes from the bottom of page 9 to the top of page 10. That quote, unreasonable restraint of trade is inferred from decades of state and federal jurisprudence. I'd be looking for a comment to say essentially that.
Okay, ask Cheryl. In the statute, to a comment, help facilitate passage of the overall bill,
Or make it worse.
or make it worse.
So I don't
Looking
know
for
that
my crystal
Cheryl's
ball.
comfortable answering that.
We'll
She's
record that. as a
hired for her antitrust expertise.
That might be a question for somebody on this commission who actually would be voting on a bill.
Senate,
Yeah.
Senator.
Who could that be?
Senator Blakespear?
Any thoughts?
Well, I like where it's landed.
Okay. All right. Moving on.
Okay, good to know. Okay, is there any objection to what we just said? Leaving the language on
Page 8.
Page 8 as it is, and then in a comment, a little explanation.
No,
Okay, I am-
no objection.
No objection. If there's no objection,
Yes, and I am noting the direction to staff, and after we get through this one, revised option 2, then we can take a vote on it. How does that sound?
okay,
To be efficient. The next one is on page 10. At the top of close to the top of the page, A1 with staff recommending or to attempt to striking out in paragraph 1, or to attempt to restrain trade, the free exercise of competition, or the freedom of trade or production.
Can you explain that to me? Why do you want to not say that? All it says is that the language does not have precedence in antitrust law. So are you worried that you're going
So-
to create something new?
That could be the concern, correct, Cheryl?
Okay.
I think some people have said that they felt the term was limited more to worker restrictions, but that wasn't, I didn't find precedent where it broadened the term restraint of trade, and some people thought we should make it simple.
And nobody knows what the extra text means.
Pardon?
Nobody knows what the extra text means anyway.
That's right.
Okay, then it should come out.
Yeah, that's correct. But it has the potential for lots of
Thank you.
judicial
Thank you for the
interpretation, so it's
Okay.
cleaner to have out.
Thank you. I'm fine with that
Okay.
coming out then.
any
If we don't understand it, we shouldn't say it.
Yeah. I just wanted to make sure that everybody
Yeah.
else got that and I
got
didn't.
it, okay.
Okay, the next one was a suggestion by the Teamsters and other folks. It would modify subdivision A to specify that, or specify directly in statute whether actions are taken directly or indirectly through another entity or person, such as an independent contractor. I think the sense what I got from the commission members that you thought that was already covered in existing law. So do we have any further discussion of this one?
Just one thing on that. I think I heard Cheryl say that the courts ignore that language often. And so I'm wondering if it's worth highlighting it just for that reason.
We're now talking about the caused or directed language.
Right.
And ventures and collaborations and very fuzzy as to who actually doing it. But we have said in the statute that you are liable if you cause or direct
Right.
it. So our thought process was that that covers it.
Yeah.
This is the wrong section, actually. I'll bring it up later. Sorry.
Okay, that's okay. Okay, so sounds like the conclusion is we probably don't need that extra section because it's actually already covered by act, cause, take or direct measures or actions. Yeah, okay.
So the next one for the commission's consideration was introducing a clear and convincing standard versus the current preponderance of the evidence standard. The staff is concerned that this could introduce uncertainty into the antitrust climate. I think that my notes reflect that the commissioners also expressed concerns about raising the standard at this time. So is this something you want us to take on or not?
My inclination is no. I think
Okay.
we may need to know sort of down the road what the impact of a single firm under the existing standard is, and at some point in the future, the legislature may choose to do that, but I think I
Sure.
probably wouldn't do it now.
Okay, so the Teamsters also on page 11 had some language about anti-competitive effects in market from the challenge conduct may not be offset by purported benefits. I think that when the staff looked at this, we thought it was unnecessary because it's basically restating existing case law. I tried to listen very closely to public comment. I'm not sure if we got anything specific to this one. So I will hand it back to you, Mr. Chair.
Yeah, there were several comments basically recommending that we no, maybe I'm mixing up things. It did come up. Right?
I talked with Dan about.
I think there were
defining the
several
market.
comments
Yeah, defining the market. That was, yeah.
recommending that we codify, there shouldn't be cross benefit justifications. And I think Mr. Hepner talked at length about how the Google decision had allowed harm in one market
Right.
to be benefits in another market to justify that.
Right. What are people's thoughts about that?
This was actually the section I was referring
Okay.
to, where
There
I
we go.
think you said the courts often gloss over this. And so even though technically we probably do not need to include it, it may be helpful.
What do people think? Okay.
Chair, if I could ask a question,
Yeah.
one of the commissioners represented that our consultant had a view on this. Cheryl, is that true?
Please turn on your mic.
My mic is on. I'm not I think having just digested the Google decision, it does make me more convinced that we should maybe codify this principle because it is often ignored, even though it is representative of existing law.
That's consistent with what we're doing in other places where we're codifying existing law.
Yeah, thank you, Cheryl.
Thank you. Other thoughts from members? So this would be a new subsection below.
Yeah, staff didn't letter it,
Yeah. What the letter means.
whatever next in order.
Yeah. Any other comments? What, do?
I have one comment, Chair, just
Yes.
generally,
Oh,
whenever you're
sure.
ready to take general comments.
Well, maybe on the, do you have a thought about this, adding this paragraph related to anti-competitive effects in one market versus benefits in a separate market?
Yes, I found all that to be very interesting in the public comment, and I think I would defer to Cheryl,
Okay. Which would be?
which would be
included.
that we're
Add it.
codifying existing law
Yeah.
because it's being
Okay.
ignored.
All right. Is there objection to doing that? Seeing none?
So the consensus direction to the staff is to include this language.
Yes.
Okay, thank you. So I think that we are ready to make a decision on option 2. So-
Did the senator have a more general comment?
Yeah.
Oh, I'm sorry.
Senator?
I'm sorry, Senator.
Yeah, I just wanted
Yeah.
to say that I think this was a very long committee hearing today, but it really shows how iterative and responsive our system is, and to me, it really inspires confidence in our democracy and in representative government. And I want to thank the stakeholders who all spoke and sent in letters, and also the commissioners for the deep engagement and the professional staff. Just the whole thing, witnessing it. I perceive a lot of criticism in general of how things work, and watching this over the past many hours today, to me, just is really a reflection of the system working well. So I just wanted to make sure and say that out loud, because it's worth recognizing when things are going well.
That's-
So that's it. Thank you.
That's very kind. Thank you. So,
This we would like to, a motion. And so the first part of the question is,
Yeah.
do you want us to do more analysis? It sounds like that's no. So does somebody want to make a motion to adopt?
I'll go
the-
ahead and do that.
Yeah.
Yes.
Okay. Option 2 as modified by the several changes that we've concurred on.
I will second that motion.
Okay, it's been moved and seconded.
Okay,
Call the roll.
I will. Commissioner B,
Aye.
Senator Blakespear,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye.
Okay,
Okay. On
okay.
to the purpose statements and whatnot.
Right, so let's go to the basic purpose statement. That is on page, let's see, where is it?
12.
The basic purpose statement is on page 13.
Sorry.
Basically, I think the consensus is that subdivision A, the purpose of this statute, that is how you want that one drafted?
Yes, that was the consensus earlier on, that we don't say legislature finds and declares, the statute will explicitly say what the purpose is.
So I think maybe just for the record, it's cleaner if we go through all these different iterations.
Mhm.
So if we could get a motion
On page 13.
on what appears on page 13, and I know we're gonna
I'll move.
add some more
Okay.
stuff into
Yeah,
it,
I'll
so.
move the text. It's in section A minus the bracketed
Yeah.
portion that precedes it.
Is there a second?
Second?
Okay. Been moved and seconded. And call the roll.
Commissioner B,
Aye.
Senator Blakespear,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye.
So the next thing that we need to talk about is the enhanced purpose statement. And I think we already covered it by saying in the last motion, we were gonna move B of the enhanced purpose statement, combine it with the basic purpose statement. Am I correct in my understanding?
Believe that's the case.
That's what I heard.
Yeah.
Okay, so then we don't need a motion on this. The statement reflecting California's laws, preferences, and priorities that appears on pages 16 and 17.
This is the one that we were going to reorganize.
Okay.
Is everybody keeping up with me? Sorry, I'm
Yeah.
trying to march us along.
Okay, 16 and 17. I got you. Yes, we were going to reorganize that.
Yeah, so I think what I'm hearing is get rid of A and move that case law into D, and then reorder it to the, now D would be A.
Mhm.
Now C would be B.
Mhm.
And so basically A and B would be stricken.
Did you want to include subdivision E and
Yeah, we're
that?
keeping E.
Oh, I'm sorry.
Yeah.
Turn the page. And
E-
subdivision E has been rewritten per the instructions of the commission.
We felt that current E should stay after current D.
Yes.
Wherever current D moves to, which I think becomes A. So current D becomes A and current E becomes B.
Okay, okay.
And then current C stays C.
Right.
Was what I
Okay.
remember.
I'm following along. Okay, so D is now A.
Right.
Mhm.
E is now B.
E is now B.
Right.
C stays
And C is still C.
Right.
Yes, it is.
Okay.
Is Is
Do
that right?
Yep.
Yeah.
we want to do a motion on this one?
I will move what I just said.
Second.
I don't want to repeat that.
Moved and seconded.
Okay. Okay.
call? Yep.
Commissioner B.
Aye.
Senator Blakespear.
Aye.
Commissioner Carrillo.
Aye.
Commissioner Hebner.
Aye.
Commissioner King.
Aye.
Commissioner Simpson.
Aye.
Okay, now we are on the statement clarifying that specific elements of federal precedents are not binding. This is probably the most difficult one, and then we should probably revisit the discussion in the context of the misuse of market power memo and the other things that were specified. And at the end, I would ask for a motion to direct staff to prepare a tentative recommendation, but let's go back to page 20. So based on commission feedback at the last minute, the staff provided two options. One would be a legislative finding and declaration. The other would be a comment. The staff recommends doing it a comment, and if the commission wants to include this language, it be in statute. One question that would benefit from clarification is, if you do want this, would you want it to be an uncodified finding and declaration, or would you want it to be in the business and professions code? And I don't have any notes that have any revisions on this one.
And this is the list of findings that a court would not
Would
be
not
required to
require.
make in order to determine liability. And these findings had been required by federal decisions over some number of years. And the purpose here is to make it clear to California courts and presumably to federal courts adjudicating California law that these findings are not required to be made in order to find liability. Is that close?
And just to add to that, it would be a non-exclusive list.
A non-exclusive list. Okay, is there, what are, do commissioners agree that in some location, it would be important to include this list of things that, findings that of course don't need to make?
Yes.
Yes, okay. Okay, in that case, where do people think we ought to put it? In the Business and Professions Code, in the statute would be one. In an uncodified section, it would be statute, but an uncodified section of the bill would be in.
I was going to ask you and Senator Blakespear which of these options is preferable, because I seem to recall that if it's uncodified, that it may not show up in all versions of the statute. You know, so you might see it on Lexis, but you won't see it on Westlaw. Or you might find it in Deering's, but not in another code book. Or
That's correct.
It'll be hard to find, or it'll be unconnected from the text.
Right, correct.
So from a
Senator-
drafting perspective, which one is
Yeah,
preferable?
Senator Blakespear, do you have a thought on that?
I don't have really any background to be able to answer it, but I
Okay.
mean, I am persuaded by just that last comment that putting it together, if we are including it, that it be proximate, so you don't have to reference something else, does seem like it's more straightforward. But I don't really know the relationship between the Business and Professions Code and the statute. Maybe we should ask Cheryl if she has an opinion.
Cheryl?
Obviously, it's more accessible and more proximate if it's in the Business and Professions Code.
Right. Other
So what do
thoughts?
what do
Commissioners?
folks
members?
think?
Is there any reason not to put it in the statute and demote it, so to speak, to a comment?
I suppose there could be an argument is that they thought it was important to put this other language in statute, but this one, I mean, if it's a legislative finding and declaration, it's not, as directive, obviously, as
Yeah.
something that's in statute. I wish Kara was here because we could
Yeah.
ask her if she thought there was a
Yeah.
difference between it being codified
What difference is
in
if it goes,
statute.
if it goes in a comment, it's not a legislative finding?
Correct.
Yeah, that we recommend against the comment approach.
Okay. To me, that's a reason to put it in the statute,
Well, in the code.
in a code.
In code,
Yeah.
yeah. It would be in the statute, but in the code.
Yeah. To codify it, not uncodify it.
Right, right.
So I'm sensing the will is to codify it. You will get another, if you direct staff to do this as a tentative recommendation for
Right.
the next meeting, you will get another crack at it.
Okay, and let me ask this, on the language, which we're looking at page 20, right?
Mhm.
Yes.
If we're gonna put it in the B and P code, should we express it as legislature finds and declares that the da-da-da, or should we say the following,
Could you start it with although?
yeah, although the following may constitute evidence of violation of this chapter, California law does not require a finding of any of the following conduct elements to establish liability. And then take out the legislature further finds and declare not for, let's see. Anyway, take out, make it as opposed to, make it part of the statute, similar to the list in, was it 16,720 of the
So you'd strike out,
behaviors.
legislature further finds and declares
Yeah.
that both places where it occurs.
Correct.
Start with although and
Correct.
start with, this is a non-exclusive list of conduct, period.
Declares that the following,
If
yeah,
you,
yeah,
if you strike legislative findings and declares, it would say that so finds, I think you would have to start with, although, which is kind of a weird
Yeah.
way to start a
I'm fine with it.
statutory sentence, but,
fine with it.
but we could play with it. So it'd say, although the following may constitute evidence of a violation of chapter
blah, blah.
California law does not require blah, blah, blah.
Yeah.
Of any of the following elements to establish liability,
Period.
period.
Next sentence. This is a non-exclusive list of conduct.
That's a little weird.
Could make it the following is a non-exclusive list of conduct.
Yeah.
I mean, if we understand what
conduct.
the direction is, I think with
Yeah.
some time we can come up with something like including but not limited to.
Yeah.
I think Rick's point is take out the legislative finding and declaration
Yeah.
part
Okay.
as unnecessary.
Right. If we're going to put it in the BNP code, yeah.
Yeah. Yeah.
Okay.
And I'm okay with that.
All right. Is there objection to that suggestion?
No
Anyone?
objection.
Okay.
Did Commissioner Hebner want to say something?
He said no objection.
No
Okay.
objection. Okay. Then,
motion on that?
Yes, please.
yeah.
The motion is that we put it in this business professional code and we remove the reference to it being legislative.
Findings, right. Okay. Yes.
Okay.
Thank you.
So
All right.
I will call
The roll?
the roll.
I will second that.
Oh,
Okay.
thank you. Commissioner B,
Aye.
Senator Blakespear,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner King,
Aye.
and Commissioner Simpson.
Aye.
Okay,
All right.
so at this point, do we want to revisit the discussion that we had about the language in the misuse of market power drafts that we had discussed earlier? I think part of what staff was, or the way it was drafted, is it calls out certain conduct. So if you go to the misuse of market power memo on page 4, that's memorandum 2543. And if you look at subdivision A, it looks like there's 8 things that that are called out to define when somebody has a person has substantial market power. My understanding is that the listed things here are not necessarily illegal, but there could be concern about what the impact is when somebody who has substantial market power engages in these activities. So with that context, I'm not sure how to recommend or approach putting this in the single firm
Right.
market, single firm conduct provisions at this time.
I think we had the conversation that looked at what the negative outcomes of behavior were, as opposed to the behaviors, the behaviors themselves. And I think those aren't, is it in the existing BNP code that has the negative outcomes of anti-competitive behavior as opposed to the specific,
The list that Dan and I were discussing is in 16720,
yeah.
which is a list of acts.
But more generic than these specific ones, right? I can't remember the thing. I had that on my phone.
I don't know if they
I'm
track
not
each other exactly.
So,
Ask a question?
Yeah.
Question. So my understanding is that these factors are important when a body has substantial market power, that outside of that context, it's not as relevant. Is that fair?
yeah, I think Cheryl can probably speak to that more artfully than I can.
I think this is conduct that is not considered anti-competitive unless it's done by somebody with kinds of activities can have particularly effects, which is the benefit of this kind of abuse. Not just to say, oh yeah, well, that conduct may be we're going to ask you to, as consumer benefits that outweigh the harm of the conduct. Trying to that and
So, I think that what staff is struggling with is the commission's already expressed that they don't want a proposal on misuse of market power and,
Right.
you know, all the arbitrary thresholds, et cetera. How we would craft something in the single firm conduct context without having a definition of substantial market power to make it work, given that this list is of things that are legal behavior, is where we're really struggling to reconcile the actions. So, you know, one option, okay.
Cheryl, walk through this with me. I'm looking at the list and it occurs to me that I'm wondering, do we even need this? So let's assume that the option 2 single firm conduct structure that we just walked through, like let's say that passes and a single firm is charged with an antitrust violation for doing some of the things that are in this list, like bundling or refusing to deal or denying the use of essential facilities, like any of those things. If this list doesn't exist anywhere in the law, can those activities still be found to be an antitrust violation by a single actor?
absolutely, and that is the argument. Well, the tentative actions. I think the real thrust of this, though, is to or a more even playing field, because you have such an asymmetry of resources between the government and these dominant parties. Like the Google trial absorbed heaven knows how many people and cost millions and millions of dollars. You don't have many of those trials, and you don't have many opportunities to challenge the conduct because it's just such a resource intensive exercise. So as I say, the real value in this is change.
And if I
Otherwise,
could-
it doesn't make anything anti-competitive that wasn't already,
Mhm.
wouldn't be deemed.
It just makes these things more obviously anti-competitive. So it sort of removes the first step for the government to have to fight that issue because they're already established.
Just to clarify, I think walking back to another question, I think this list is a little bit less relevant if we aren't pursuing an amendment.
Right. And I understand the anxiety folks have about you know, multi-million-dollar antitrust suits and things like that. But I'm a little uncomfortable changing the law to whether it shift the burden of proof or a list of things that we would, I mean, change the policy on antitrust law in order to make it easier to file lawsuits. less expensive to file lawsuits. That makes me a little uncomfortable. So,
Back to the proof of the justifications for the con. So that those justifications outweigh the harm. The challenger, the government still has to prove the conduct has anti-competitive effects.
right.
And
but-
that in and of itself is often a 6-month trial.
Right, but when you say changing the burden, you're shifting the burden of proof from the plaintiff to the defendant? I mean, from the plaintiff to the defendant?
Government has the burden of proof and plaintiff has a burden of proof. And have different proposals. Some would change the burden of. Some would say, well, you have to show that. Depends on how you draft it.
So-
David?
Oh, I just wanted to throw something out there. I think this is a pretty complicated discussion, and the commission already said stop on misuse of market power.
Mm.
At the same time, if you want staff to go back and provide you more, we could do that. But I think if we keep talking about that, it's gonna bog down moving forward what we have so far on single firm conduct. And like when we were talking about misuse of market power before, I don't think it's necessary that they move forward at the same time. If at some point the commission wants to revisit the issue, it can. So that's my thoughts.
Well, my concern was, if we're going to, cut and paste some or all or some version of this and put it in single firm, we should do that now, because the whole point of moving on single firm is so that we can get a public comment process going for a draft recommendation. So it seems to me like if we're going to do something with that, we kind of have to do it now, because otherwise that effectively kicks, it either kicks single firm to the next meeting, or people will be commenting on something that they know is incomplete, because we might be adding some stuff, and neither one of those is preferable.
If I could,
And if I may finish, my solution is I think we forego this. When I was talking with Commissioner Simpson a second ago, the two lists don't exactly sync up like in terms, but they do conceptually. So if you look at things like denying use of essential facilities or resources, well, that's subdivision B, limiting or reducing the production or increasing, et cetera.
Yeah.
There's subdivision A, creating or carrying out restrictions in trade or commerce. That syncs up with subdivision 4, refusing to deal, subdivision 7, self-preferencing. So I think conceptually there's a lot of overlap here, and I'm comforted by Cheryl's description of this as like these are already captured by existing law by 16.720 already. So my suggestion is we forego this, not contemplate adding it in the future, and leave it on the table and move forward with what we have now on single firm conduct.
I would agree.
Second.
So I think since we already made a decision on misuse of market power, we don't necessarily need a motion, but it never hurts if you want to go ahead and say, I guess, I don't know how to say it exactly.
I would move that we leave memo 43 as is and not move forward with it in any context.
So we're kind of reconfirming the motion that's already been made, or that motion stands.
Yeah, well, there was a potential reservation that we might be cutting and pasting this list or something else, and now I'm confirming we're not doing that.
Okay.
Okay, yeah.
Okay, so
Like there was a motion and second.
a motion and
There
second
was,
on, yeah, there was, absolutely, yes.
Yeah.
It was voted on. Okay, so then,
We would vote now to because we left this list or standing as something we might
Okay.
take up later. So let's vote. We're not putting this list into
Thank you.
single firm.
Okay, let me just take a note. Okay. Do we have a motion and
We
we
did.
had a second too?
We did, yes.
Okay.
Maria.
Okay, thank you. Commissioner B,
Aye.
Senator Blakespear,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye.
So now it would be great if we got a motion directing staff to prepare a tentative recommendation for consideration by the commission at its next meeting on everything we just worked through.
So moved.
Second.
Been moved in second. Call the
Okay,
roll.
Commissioner B,
Aye.
Senator Blakespear,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye. Okay.
We made it through
Thank you,
single
everyone.
firm
We made it through
conduct.
Single firm.
Don't sound so surprised.
Well, it's taken a while, but you know,
Can we get a 5-minute break?
well, let me ask this. It's almost 4:30. Do we want to start taking up mergers and acquisitions?
No, I would
Or
move
do
to,
we want to put that over until the next meeting?
I would move to adjourn.
Maria? Next meeting? Next meeting?
It would be, I mean, I
Yeah.
will say it would be impossible to get through the whole thing.
That was
so-
my thought exactly. So, why don't we,
I renew my motion to adjourn.
all right, it's been moved.
I call the question.
Yeah, it's been moved to adjourn.
Do I need to take roll?
No.
I don't think
And
so.
is there any objection? Is there any objection to adjourning? Hearing none?
Use your gavel and.
Oh, man.
Bang us out.
Am I
Official.
gonna,
Come on, Rick,
am I
use
gonna
that
whack with
thing.
this? All right. We are adjourned.
Thank you.
Thank you, everyone. for
Thank
your-
you. Thank you, everyone.
Well, it was sitting here, so I you know, I would,